Still ready for trial?
Yes, sir.
Okay. All right. Did we talk about which week would we potentially do?
The
for you?
8th, next week.
So next week. Okay. So he'll be here for
He's been instructed to be here on the jury review for Friday.
Friday at 9 o'clock.
Yes, sir.
Okay. And we talked about 3 days, correct?
Yes.
That's my anticipation.
Okay. Anything else that we need to discuss today?
Not today, Your Honor.
Any issues with subpoenas or witnesses?
No, there are two pending notice of Williams rule that I filed. One, I filed it in February, and the other one last week,
When would we like to hear those?
whenever the court decides.
Want to hear them on Friday?
Friday or Monday after jury selection, either way, whatever the court prefers.
My concern on doing them after jury selection is I don't know how many juries I'm going to be picking that day.
Yes, sir.
Because although if it was just yours, probably would be plenty of time to do that. But my concern is, as of right now, I have 18 set for the 2-week period. That may be 15 by the end of today. It may be 2 by the end of today. I just don't know. So I would say let's plan on doing that Friday at docket day or at jury review.
Jury review, that's
Yes,
fine,
sir.
Your Honor.
Okay.
And I'm assuming you've reviewed those, Mr. Keach, and
Yes, sir.
object.
Yes, sir.
Okay.
We object strenuously.
All right. We'll see y'all back on Friday at 9 o'clock.
Yes, Your
Thank you.
Honor.
All right, thank you. Ms. Merrifield?
I need just another moment, Judge.
Okay. Do we have any other lawyers who are ready?
Judge, there's a couple of cases that I could call. Regina Alford. Judge, this one's set for a competency hearing.
All right, I know we had talked about putting the competency hearing on the 25th of September. I think then we went from there to talk about just discussing it today. I was able to read the evaluation over the weekend. I think the issue was going to be a further evaluation.
There is not, Your Honor.
Okay. All right, so we're all stipulating to the court making its determination on the one evaluation.
That's correct, Judge. Does the court have a copy of that evaluation?
Should be in this stack because I just read it over the weekend.
If not, I've got an extra copy.
I think I read it yesterday.
And the state is fine with that as well, Your Honor.
All right. The court's previously reviewed the evaluation that was submitted by Dr. McDonald. That evaluation was from June 26th. Based on that sole evaluation, I will find that Ms. Alford is not competent to proceed at this time. And are you going to pursue the APD issue? I think it's that.
Judge, I'm fine.
Dr. McDonald's recommendation was
Yes, Your
an
Honor.
APD.
That's what the
We're
state
fine
would
with that,
request.
Judge.
All right, so if you'll get me an order on that, Mr. Williams. But I'd like to kind of bring it back to make sure everything's going well.
Yes, sir.
Why don't we put it on that October 9th date at
All
9
right, Judge.
o'clock? So it gives us about 5 weeks or so to get that evaluation going. I know Mr. Maddox has a few of them that he's dealing with, so he should be able to give you whatever marching orders they've given to him to make sure it goes streamlined.
Yes, sir.
All right. So Ms. Alford, you're going to meet with another doctor or talk to them about services, and we'll see you back on October 9th at 9 o'clock, just to make sure everything's going as needed.
Yes, sir.
All right. Thank you, Ms. Alford.
Okay, ma'am.
File that under seal. Merrifield?
I'm ready.
All right, come on up. They've got all your people lined up.
I have Sampson and Graham. If I could have just a brief moment, we had a little bit of a change.
Okay.
Thank you. That's a good one. Which one is that? Let me see. No, there's no statute.
Okay, thank you. Thank you, Judge. Brady Merrifield on behalf of Sampson, Graham, and 24 CF 2660. We're also going to be resolving 25 CF 877. That is a South End case. We did put that before Judge Clark, and it is included in the minutes that that case could be resolved
What's the number again?
with this case. 25 CF 877. If I may approach.
Let's see if this one works today.
Ms. Basso and I have confirmed the score sheet. Technical difficulties prevent us from printing it, Judge.
But I do have the points for the record if the court wishes those.
Sure. What was the total points?
Yeah, the total points are going to be, well, the total lowest permissible is 45.8 months DOC with a maximum of 25 years. So this will be within the guidelines.
No objection to the points, Judge.
And it's 66.8 points.
And just so the court is aware of the minor change that we had this morning, I've met with Mr. Graham on multiple occasions to resolve both of these cases. Mr. Graham brought it to my attention that he was recently told about a restitution issue in the South End case. So I've added some language, reserve as to restitution to Niceville Police Department. We need to verify that because I'm not able to confirm what the amount is and all of the details with that, Judge. But it did not change his desire to enter the plea today.
All right, Mr. Graham, raise your right hand. Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
Can you state your full name and date of birth, please?
Sampson Matthew Graham, February 25th, 1991.
All right, Mr. Graham, you're here in 24 CF 2660. Oh, that's not the right number. Yes, it is.
It is the correct number.
It's the below, right, you've got the wrong, you've got 2462.
Thank you, Judge.
Yeah,
Yeah, it is 2660.
okay. So that's the one on the style of the case, but it's not the one down here in the
Thank you,
count.
Judge.
So let me just change that so we have it consistent. All right, Mr. Graham, you're here in 24 CF 2660, charged with using a computer to facilitate or solicit a child, third-degree felony, punishable up to 5 years in state prison. Count 2 is traveling to meet a minor, is a second-degree felony and punishable up to 15 years in state prison. Count 3 is unlawful use of a two-way communication device, third-degree felony, punishable up to 5 years in state prison. And then you're also here in 25 CF 877 with 2 counts of aggravated animal cruelty, which are third-degree felonies, punishable up to 5 years in state prison. Do you understand that?
Yes, sir.
I have a plea and sentencing agreement between you and the state that would call for you to enter a no contest plea to count 2 of the 24 CF 2660. The state would then dismiss counts 1 and 3, and also to plead no contest to both counts of 25 CF 877. In return for your plea, the agreed-upon sentence between you and the state is 60 months of Department of Corrections with credit for all time served, followed by 120 months of sex offender probation. Y'all have agreed that you may request early termination after 60 months, provided there have been no new law violations and all conditions have been met. Do you understand that you're not entitled to early termination after 60 months, but simply that you can ask for it? Okay. 40 months or $40 per month cost of supervision, standard court costs, if you could get those for me, Madam Clerk. No contact with any minors until the completion of a risk assessment, and upon approval from probation, GPS at $1 per day pursuant to JLA. Don't be in any place that minors congregate. No electronic devices capable of accessing the internet. No use of the internet. And once you've done the risk assessment as allowed by statute, you can petition the court for use of internet capable devices. You'd be designated as a sexual offender under 9430435, and that you have to do all the statutory requirements about that. Do you understand what those are?
Yes, Your Honor.
Did you go over those with your lawyer as well?
I did.
Okay. And that you would forfeit any seized devices. You understand that?
Yes, Your Honor.
Is that what you want to do today?
Yes.
All right, have you gone over this plea and sentencing agreement with your lawyer?
Yes, Your Honor.
Did you understand it?
Yes, Your Honor.
Did you sign it?
I did, Your Honor.
Are you satisfied with your attorney's advice and representation?
I am, Your Honor.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, I am not.
Are you currently suffering from any mental health issues or concerns? Has anyone forced, pressured, or threatened you in any way to enter this plea?
No, Your Honor.
Has anyone promised you anything in return for this plea?
No, they have not, Your Honor.
You understand by pleading no contest to the 3 counts that there will be no trial of any kind?
Yes, sir.
And do you understand you're giving up your trial rights, which are on page 2 of that agreement that you signed? Understand you're waiving any potential defenses that you may have?
Yes, Your Honor.
And do you understand that if you're not a U.S. citizen, this plea could lead to your deportation?
Yes, Your Honor.
I don't think I previously said this, but you understand you'd be adjudicated of the 3 counts that you're pleading to, so that would be 3 felony convictions. All right, and it's the 60 months Department of Corrections followed by 120 months of sex offender probation. Is that the stipulation and for the sentence by the state?
That is, Your Honor. We'd also announce the null pros of counts 1 and 3 in 24-2660. They're subsumed by count 2.
Was there a concern about double jeopardy between 1 and 2? Is that part of the reason?
Yes, Your Honor. The event.
I know it's fact specific, so I don't know all the
It was in this
specific.
case, Your Honor. They did occur on the same day as part of the same instance, and we believe that was appropriate once it was raised.
Okay. All right. Based on that, Mr. Graham, what is your plea to 24 CF 2660 count 2?
No contest, Your Honor.
And what is your plea to 25 CF 877 counts 1 and 2?
No contest, Your Honor.
All right. I'm going to accept your no contest pleas as freely, voluntarily, and knowingly given. In 24 CF 2660 count 2, it's going to be 60 months in the Department of Corrections. Excuse me. With credit for all time served, followed by 120 months of sex offender probation. You may request early termination after 60 months, but as I've stated previously, that's not guaranteed. But that would require that you've had no new law violations and met all of your conditions as part of your probation. $40 per month cost of supervision. Did we get costs? Yes.
Does the court need the particular statute?
I think it's just the subsection.
It's 4A. Are you talking about for count 2, Judge?
Or no, for the 25 CF 877, is it 2A or 2B?
82812 subsection 2.
That's all it says, but they have a different cost based on A
Yes,
or
sir.
B, so I'm trying to look that up.
Oh, sorry, did this one. Trying to figure it out real quick.
I think it is just 2. Because A would be there's a factual determination that has to be done.
B was second of
And B is a
subsequent.
second offense. And so neither of those have been done, so it's just 2. Then it's 515 court costs.
515?
All right. All right, no contact with any minors until the completion of your risk assessment and upon approval from probation. GPS monitor at $1 per day pursuant to the Jessica Lunsford Act. Don't be in any place that minors congregate. No electronic devices capable of accessing the internet. You may petition the court for internet use after the completion of that risk assessment as allowed by statute, but again, that's something that you'd have to come back to court about. You'll be designated as a sexual offender in accordance with 943.0435 and be required to do all statutory requirements pursuant to that statute that you've gone over with your lawyer already, and you have to forfeit any seized devices. States announced its intent to null pros counts 1 and 3. In 25 CF 877, count 1 will be 60 months in the Department of Corrections, concurrent with count 2, as well as 24 CF 2462, reserve as to restitution to the Niceville Police Department. Count 2 would also be 60 months Department of Corrections with credit for time served, concurrent with count 1. And count 2 in 24 CF 2462.
Judge, that would be concurrent with count 1. They would all run together, and then count 2 in the 24, or I'm sorry, the 2660.
So basically, you understand, Mr. Graham, that you're receiving the maximum penalty on the 25 CF 877. That's why there's no probation. So he'll only be on probation for 24 CF 2660, count 2, right?
Correct, Judge.
Once he's out. All right, adjudicate you guilty on all 3 counts that you've entered a plea to. And then this is a guideline sentence, but you'll have to provide me those guidelines.
Yes, Your Honor, as soon as I get a printer cooperate, I'll get that to you.
All right, so, Mr. Graham, you're doing a 5-year DOC sentence, but you're going to have probation after that, so you're going to have to meet with probation right now so they can give you some instructions, but obviously, you'll have to report basically immediately upon your release from the Department of Corrections. Do you understand that? I'm also going to need your fingerprints, and then you've got 30 days to appeal the judgment and sentence of the court.
Judge, can we have 180 days to make cost upon release before it gets sent to a judgment?
How many days?
180?
Let's go 90, because you can set up a payment plan for those
Thank you.
costs as well. did I give court costs on this first case? I don't remember saying it.
I don't believe so. I heard court cost of $515.
$515 on each case? $515 each case. All right,
Thank
then
you,
you have 90 days upon his release to either pay the costs or, well, he'll be on probation. Well, just for the other case.
And the only other thing I did not hear you
Let me
announce.
make sure I say that then.
Yes,
So
sir.
on the 25 case, 877, he'll have $515 in court costs. He'll give him 90 days upon his release to pay those before they go to a judgment. You can also set up a payment plan for that purpose. Since technically, well, you won't be on probation for those counts, I can't have you just pay those during probation.
Right, understood. And then the only other thing, Judge, on 25 CF 877, I didn't hear the announcement we're reserving as to restitution.
I think I said that.
It was discussed earlier, but I don't think it was in the final pronouncement, Your Honor.
I don't believe it was,
Okay.
Judge. We'll have
All
to
right.
bring this back up once I acquire the documents. Like I said, we just found out about this prior to the plea.
Okay, so I'm going to reserve on restitution to the Niceville Police Department.
Thank you, Judge.
Thank
I believe
you.
that's all I have.
Out to probation. Is that all you had, Ms. Merrifield?
It is, Judge.
All right, Mr. Switek, are you ready, or are you still working yours out?
Shuttle diplomacy, so pass mine, please.
Is that a yes or a no?
No, I'm not ready.
Okay. All right, Ms. Rivers or Mr. Russell?
I can do the ones that,
I just don't know who's lined up to go.
I have one out of custody, Judge.
All right, go ahead.
Adam Frederick. For the record, case number is 25 CF 005. Mr. Frederick is present and approaching. We've worked out a plea agreement to misdemeanor, so there will not be a score sheet. May I approach?
Yes, sir.
What day of the week is it? It's Tuesday. Okay, let's see if I can find a spare Pierce one. Maybe I have a spare Pierce one.
Can you raise your right hand, Mr. Frederick? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth? All right, can you state your full name and date of birth, please?
Adam Matthew Frederick, 9/21/83.
All right, Mr. Frederick, you're here on 25 CF 005. Charged with drive while license suspended, third conviction, which would make it a felony, punishable up to 5 years in state prison. Do you understand that?
Yes, sir.
I've been handed a plea and sentencing agreement between you and the state that would call for them to reduce the charge to a first-degree misdemeanor, adjudication of guilt, $300 in court costs, $100 PD fee within 90 days, or a judgment. You also could try to set up a payment plan within those 90 days. Do you understand that, Mr. Frederick?
Sir.
Is that what you want to do today?
Yes, sir.
Did you go over this with your lawyer?
I did.
Did you understand and sign it?
Did.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues or concerns?
No, sir.
Has anyone forced, pressured, or threatened you in any way to enter this plea?
No, sir.
Has anyone promised you anything in return for your plea?
No, sir.
And do you understand by entering a plea, you're giving up your right to a trial and your trial rights, which are on page 2 of that agreement you signed?
I do.
All right, do you understand that you'll be waiving any potential defenses?
Yes, sir.
And finally, do you understand that if you're not a U.S. citizen, this could lead to your deportation?
Yes, sir.
All right, and it's an adjudication of guilt. All right, so the state's agreement, Mr.
It
Sheehan?
is, Your Honor. I just wanted to put on the record that the defense had asked me to review his driving history, and this is the appropriate charge since he did not have more priors, which is why we don't have a 10-day sentence on there, Your Honor.
Okay. All right, so Mr. Frederick, what is your plea to the misdemeanor drive while license suspended?
No contest.
All right, I'll accept your no contest plea as freely, voluntarily, knowingly given. Adjudicate you guilty, $300 in court costs, $100 PD fee. Pay those costs within 90 days or otherwise make a payment plan. If you don't do either of those things, you'll be sent to a judgment.
Sir.
All right, thank you. I think we need fingerprints from him since it's drive while license suspended.
And Judge, I forgot, I do have one more that I can call. Laura Coleman, case number is 24 CF 1471. This is the one that we filed an insanity defense on, depots Friday. 1 out of 4 witnesses showed up for that, but we had waived Ms. Coleman's appearance previously and waived it for today because she lives in Louisiana. Today, defense is asking for a continuance We found out during the depositions that the alleged victim has moved, so the state's going to have to look for him, and/or they're still looking at the insanity defense. So we're just asking for a continuance to the next pretrial conference.
Be October 27th at 1 o'clock. I know we talked about the issues potentially with witnesses last week, so waive her appearance here today and set it for that next pretrial conference.
Great. Thank you, Judge.
Let me see if I can fix this.
What was the, on the previous case, did y'all have the case number for the misdemeanor reduction?
I do have the statute number. I wrote it on
Did you write it on
the
there?
plea agreement. It's going to be, I think, 1B instead of 2C or something. No.
Don't see it listed.
Oh, no, I'm thinking of a different case. I'm sorry, Judge. No, I did not write the statute number for that one.
322.34.
Might be able to do this one. Ha, I got it.
Would be 2B.
Judge's name.
322.34 2B. All right, sorry. I thought you had that part. All right. Rivers, you have anyone out of custody you want to take up?
John Rockus, 25 CF 5, I think it's 5 or 6. 675, Your Honor.
675.
Your Honor, we are set for trial.
Is they ready for trial?
Yes, sir.
Okay. Any issues that we have to take up today?
No, Your Honor.
Have y'all talked about which week?
No.
No, we haven't, because we.
Oh, I'm just asking in case
Yeah,
y'all
no.
have done it. All right, so why don't we bring this back for Friday for jury review? That way we know how many cases are actually going to be going, and then we'll give you your trial date, whether that's next week or the following week with Mr. Ruckus. All right. So
Yep, be here Friday at 9 a.m.
that will be what, September 5th, 9 o'clock.
Jordan Rodriguez, 25 CF 992. Your Honor, she is present and approaching and speaking with the state. We're going to continue this. We're going to ask to put it on the next pretrial docket.
That is without objection, Your Honor. We wanted to verify some information.
This is the first time up, I think.
It is, Your Honor.
So 10:27 at 1 p.m., Ms. Rodriguez.
Bobby Simmons, 25 CF 1119. He is present, Your Honor, and approaching. He is ready for trial.
State ready?
Yes. And again, the weeks,
Okay,
either one.
The only reason I ask that question is in case y'all have talked about it because
Right.
you got specific witness issues or anything like that.
Yes, I do, just for the court, I do have some cases that are set that I would have a preference, but as far as this is concerned,
All right.
either one.
And I'm just asking for those because I know both of you have several that are set for trial still. So,
Yes.
all right. Any motions that we have to take up before we get to trial?
I'm sorry, Your
Any
Honor.
motions been filed that we have to take up?
No, Your Honor, no,
Okay.
no motions.
I would just like to make sure that we get those heard before jury selection.
Yes.
All right. Mr. Simmons, we'll have you back on September 5th. That's this Friday at 9 o'clock. That way we can kind of come up with a trial calendar, tell you which day to be back. All right, we'll see you on that day.
That's it. Billy, Your Honor, Billy Perdue is present, but I don't think we have an answer. Billy Perdue?
What was the answer?
Okay. Your Honor, based on my discussion with the state, I'm going to ask to put this on for 10/27.
And who is this? Is this Billy Purdue?
I'm sorry, Your Honor, this is Billy Purdue.
You said
This
that name,
is
but I'm not sure, I didn't know if that's who you were calling or not.
25 CF 1084.
All right. And Mr. Purdue was not here last week, right? We recalled that?
That's-
And then you came in on the 27th, right?
That's correct, Your
Just
Honor.
want to make sure all my notes are correct, that we withdrew the KPS for Monday on Wednesday, so there's no confusion about that. Mr. Purdue, we'll see you back on 10/27 at 1 o'clock. Thank you.
And I believe. Go ahead and do my in custody. The court's so
Are they
inclined.
set up already? All right. I think Mr. Switek's ready for whenever you want to put him after Rivers now that he's set up.
Your Honor, this is Derek Lewis before the court on 23 CF 2797. This matter, I believe the state had asked to set for trial. The state had indicated that the discovery that we had been waiting for had come in, but we haven't gotten the discovery yet. And also, the state has made a...
Is this the DNA issue again?
Yes, and the state has made in my client's view, a substantially different offer today, increase. So we're going to ask to continue it so we can get the discovery and for him to have a chance to digest what he wants to do.
You're saying the plea offer went up?
Yes,
Okay. All right. You going to be ready for a trial next time?
yes, Your Honor.
Okay, because I called this last continuance.
Yes, Your
That would
Honor.
be fine, Your Honor.
All right. So, Mr. Lewis, we're going to see you back on October 29th at 9 o'clock for your next pretrial conference. Absent some completely unforeseen or emergency situation, this case will not be continued again. Pushing on 2 years old.
Do you have Ms. Malone next? Pierce?
Oh, that's Mr. Switek.
We're not going to do this.
10 years.
All right. Mr. Switek, what are we doing with Mr. Pierce?
We're going to enter a plea, Your Honor.
That's mine.
Thank you.
Yes, sir. Oh, I didn't sign it. Thank you, sir. I'm going to assume he didn't change anything.
Your Honor, this is Jared Pierce in case numbers 25-647, 24-1948, 24-2599, and 2018 CF 2647. Written plea agreement signed by everybody. And score sheet, we had some corrections this morning, and they've been... No objection.
Could you release it for a second? Hold on. Yeah, Lisa for a second. I saw blonde. So I need to go. You talk to her, but I need to do this first. Hello. Do you have a client that wants to be a predator? I sent you for that. This guy does. You remember him? Do you have a client that wants to be a predator? No, it's client's stuff right now. Not today. No, we don't. This is the one. You're not on it.
So it's basically 7 years DOC followed by 10 years probation. I've got the breakdown now. I just had to go through it. There's
Yes, Your Honor.
needed
That's
a
correct.
map to figure it out a little bit, so. All right, Mr. Pierce, raise your right hand. You swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
Can you state your full name and date of birth, please?
Jared Pierce, 7/19/2000.
Mr. Pierce, you're here for a violation of probation in 2018 CF 2647. Then also, you're here for 24 CF 2599, where you have 3 counts of failure to register email addresses or internet identifiers. Each of those are third-degree felonies, punishment up to 5 years in state prison. You have 24 CF 1948, which is a failure to register a change to employment. Yeah, it's. Okay, and then there's, you've got 18 CF 2647, when it's 25 CF. Could be, no. Okay. I may have just said the wrong case number the first time, so let me just make sure it's clear. 25 CF 647 is 3 counts of obscene material, 3 counts of that, 5-year maximum as third-degree felonies. 24 CF 2599, 3 counts of failure to register email addresses or internet identifiers. 24 CF 1948 is the failure to report a change of employment. It's a second-degree felony punished by up to 15 years state prison, and the VOP is 18 CF 2647, where you had a total exposure of 25 years. Did you understand all that, Mr. Pierce?
Yes, sir.
Sorry, since I'm used to them being kind of oldest case first, and so I skipped over the first one. That was my fault. All right, Mr. Pierce, I've been handed a plea and sentencing agreement that would have you plead to 25 CF 0647, all 3 counts, and 24 CF 2599, the 1 count of failure to register an email address or internet identifier. Counts 2 and 3 would be dismissed by the state. 24 CF 1948 is going to be dismissed by the state. And then your VOP as well. The plea and sentencing agreement between you and the state would be that you receive an ultimate 7 years of incarceration in the Department of Corrections, and I'll go through the breakdown of that because it's kind of intricate, followed by 10 years of sex offender probation with standard terms and conditions, GPS monitor, no contact with minors, no internet access, standard fines and court costs, designated as a sexual predator based upon a prior conviction and current possession of child pornography pursuant to 775.21. The breakdown is in 25 CF 647 and 24 CF 2599, 5 years of incarceration, concurrent, all cases, all counts. The VOP 18 CF 2647 would be 5 years of incarceration on counts, it says courts, counts 2 and 3. Concurrent with each other in case number 25 CF 647 and 24 CF 2599. And then also as to 2018 CF 2647, it'd be a consecutive 2 years of incarceration on count 1. That would be consecutive to all of the other counts that were concurrent together. And then 10 years of sex offender probation, consecutive to all cases and all incarcerative charges, credit for all time served. Is that what you want to do today, Mr. Pierce?
Yes, sir.
Okay. All right, did you go over this plea and sentencing agreement with your lawyer?
Yes, sir.
Did you understand it?
Yes, sir.
Did you sign it?
Yes, sir.
Are you satisfied with your lawyer's advice and representation?
Yes, sir.
Also, I don't believe I've said this yet, but you'd be adjudicated on all counts that you're entering a plea to. Do you understand that?
Yes, sir.
All right, are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues?
No, sir.
Have you been forced, pressured, or threatened in any way to enter this plea?
No, sir.
Has anyone promised you anything in return for your plea?
No, sir.
You understand that in the new case is that you're entering pleas to, which is, again, going to be 25 CF 647, 3 counts, and 24 CF 2599, 1 count, that if you enter a no contest plea, there won't be a trial of any kind.
Yes, sir.
And do you understand that you'd be giving up your rights to a trial, which are listed in the agreement that you've signed?
Yes, sir.
Do you have any questions about your trial rights?
No, sir.
And do you understand that in the 18 CF 2647, by admitting your violation of probation, there won't be an evidentiary hearing where the state would have to prove by a preponderance of the evidence that you violated your probation?
Yes, sir, I understand.
And do you understand that you're waiving all potential defenses that you may have in these cases?
Yes, sir.
And do you understand that if you're not a U.S. citizen, this could lead to your deportation?
Yes, sir.
And is the agreement that I've announced, is that the state's agreement?
It is a state's agreement, Your Honor, and in 1948, we would announce the null pros for the record based on additional information provided by the defense.
Okay.
And on 2599, we would announce a null pros on count 2 and 3 in return for the plea on count 1.
Okay, I think you said 2525, is that 24 CF 2599?
That's correct, Judge. I'm sorry. That would be the case I'm referring to, yes.
I've got it wrong a couple of times, too. I'm also looking at the sentencing guidelines that calls for 67.95 months. So this is a guideline sentence, and that he's entering a plea to more time than he has on his
Minimum
guidelines.
Yes, Your Honor.
Okay. All right. All right, Mr. Pierce, as to 25 CF 647, what is your plea to the 3 counts of obscene material?
No contest.
And as to 24 CF 2599, which is a failure to register an email address or internet identifier.
No contest.
And as far as 18 CF 2647, your violation, are you admitting or denying your violation of probation?
Admitting.
I'm going to accept your admission of your violation of probation and your pleas of no contest. That's freely, voluntarily, and knowingly given. You'll be adjudicated guilty on all remaining charges. In 25 CF 647 and 24 CF 2599, it'll be 5 years in the Department of Corrections, concurrent on all cases and all counts. 18 CF 2647 will be 5 years of incarceration on counts 2 and 3, concurrent with each other in those previously announced cases. Also, as to 2018 CF 2641, 2 years of incarceration of the Department of Corrections on count 1, consecutive to that in 25 CF 647 and 24 CF 2599. And I guess also consecutive to counts 2 and 3 in that same case in the VOP, followed by 10 years of probation consecutive to all other cases and all incarcerative charges. You'll receive credit for all time served, court costs, Court costs will be as required by statute. We'll get that final number in just a minute. Also, you're required to submit to a blood or swab specimens pursuant to 943.325, which you've probably already done. Yes? And Mr. Switek, I believe you said you didn't have any objections to the score sheet.
I do not.
Okay, and anything that I missed in the sentencing agreement?
Request $1 a day on GPS
$1 a day on the GPS.
No objection.
Anything else that I may have missed?
and 90 days to set up a payment plan on release.
Okay. On the cases for which he's not going to be on probation, he'll have 90 days after his release from the Department of Corrections to pay his court costs or set up a payment plan, otherwise they'll go to judgment. On the VOP, I believe it'd be $100 cost of prosecution, and in 25 CF 647, $666 court costs in that case, and then in 24 CF 2599, that'll be $515.
666.
Not funny, Mr. Pierce.
I was just asking about the 666. So.
All right, Mr. Pierce, I need you to talk to probation. They'll give you some instructions for once you're released from prison. You have 30 days to appeal your judgment and sentence. I'll also need your fingerprints before you leave this morning. Thank you.
Your Honor.
Thank you, sir. And Mr. Switek, we'll see you on Thursday morning still.
Yes, and if I could move that to 9 o'clock. Case in Definiak has been disposed of.
I have other things that morning. That's why I was willing to do it later. I've got 2 civil hearings that morning.
All right, 11 will be fine.
Your Honor, this is Diana Malone, 21 CF 923. We are set for trial. If I may approach, Your Honor, with the state.
Yes.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m. serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by.
I'm Amanda Gaskin with Briar Patch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
You've been injured in an accident and need righteous representation? Call us, because we fight fire. Damn thing ain't working. Whoa! Not cool, bro.
I'm attorney Coy Browning. Personal injury is no joke. Just ask him.
Injured? Take a breath. Call Coy.
All right, this is Diana Malone, 21 CF 923. We're going to keep this case set for trial, but to discuss the issues we discussed at the bench on Friday, September 5th, once the court's had a chance to review the case law that will be provided.
All right, I'll be seeing you.
Mm-hmm. 9 a.m., yes. Ms. Dudley here.
Your Honor, this is Destiny Jackson, 24 CF 852, 24 CF 1681. I did get the search warrant on Friday afternoon.
I'm sorry, the name was?
Destiny Jackson, Your Honor.
Okay, there it is.
Your Honor, I did get the search warrant. I do expect to file a motion. I would ask for a continuance to the next cycle. It was set today, just P or C. I am still waiting on the cell phone downloads. I have provided the hard drive.
State?
I don't object.
Okay. Well, these cases are getting old, so let's try to get all this, the motion filed and heard before the next date.
Yes, sir, I will.
It's certainly, let's get this
Absolutely.
discovery download sent over. So it'll be October 27th October 29th at 9 a.m. for pretrial. Is there anything else other than the phone downloads you're waiting on?
Thank you, Your Honor.
Ms. Dudley, maybe you didn't hear my question. Is there anything else besides the phone downloads
No,
you're
sir.
waiting on?
I'm sorry. I apologize. No,
That's
sir.
fine.
That's the last one. And I just need to have him sign this real quick.
aren't all the terms, and we're going to figure out what he was going to plead to. We're going to have to do a custodial. We can do it. We can do it on another day. It just isn't.
Your Honor, if I may approach.
Yes. The total of it would be 6 years DOC followed by 5 years probation.
Correct, Your Honor. I just want to make sure the third degree felony is.
I'm just trying to read it all through there, and you've got it all typed out perfectly. I just wanted to make sure I got
Yes, sir.
everything. All right, Mr. McGee, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, can you state your name and date of birth, please?
Gil McGee, 1988, August 26.
Okay. Mr. McGee, you're here currently charged with in 24 CF 376, 2 counts of aggravated battery with a deadly weapon, which are second-degree felonies punished by up to 15 years in state prison. Felony battery and tampering with evidence are both third-degree felonies punished by up to 5 years in state prison. Criminal mischief, it's a misdemeanor punished by a year. And count 6, tampering with a witness, a second-degree felony, which is a first-degree felony punished by up to 30 years in state prison. Also 24 CF 669, 1 count felony battery, third-degree felony, and 1 count tampering with a witness by depriving them of communication is a second-degree felony punished by up to 15 years in state prison. You understand what you're currently charged with?
Sir.
I have been given a plea and sentencing agreement between you and the state that would have the state dismiss counts 2 and 3 in the 376 case. You would enter a plea of no contest to all other counts. And 24 CF 376 would be an adjudication of guilt on all charges that were not already dismissed. 6 years Department of Corrections on count 1, 5 years DOC on count 4, time served count 5. Those would be concurrent with each other, and also with the following case I'll get to. That would then be followed by 5 years of probation on count 6, $867 in court costs, no contact with the victim, credit for all time served, reserve on restitution for a period of 120 days. You'd also, during your probation period, would have to do the batterer's intervention program. Do you understand that?
Yes, sir.
All right. Also, for the probation, it'd be $40 cost of supervision. And then in 24 CF 669, it'd be an adjudication of guilt on both counts. 5 years DOC on count 1, 6 years on count 2, concurrent with 24 CF 376, 867 court cost, credit for all time served. Is that your understanding of the agreement?
Sir.
Is that the state's agreement?
Yes, Your Honor.
Mr. McGee, is that what you want to do today?
Yes, sir.
All right. Have you gone over this plea and sentencing agreement with your lawyer?
Yes, sir.
Did you understand it all?
Yes, sir.
And did you sign the agreement? And are you satisfied with your lawyer's advice and representation? All right. Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues? Has anyone forced, pressured, or threatened you in any way to enter this plea?
No, sir.
Has anyone promised you anything in return for this plea? You understand by entering a plea there won't be a trial of any kind, and you're giving up your trial rights, which are on page 2 of the agreement you signed.
Yes, sir.
And do you understand you're waiving all potential defenses?
Yes, sir.
And do you understand that if you're not a U.S. citizen, this could lead to your deportation?
Yes, sir.
All right. And it's my understanding this will be a guideline sentence according to the guidelines I've received that show 51.375.
Yes, sir.
All right. All right, Mr. McGee, what is your plea as to 24 CF 376 counts 1, 4, 5, and 6?
No contest.
And as to 24 CF 669, how do you plea to both counts?
Contest.
Oral accept your no contest pleas as freely, voluntarily, knowingly given. State have an announcement in counts 2 and 3 in the 24 CF 376 case?
Yes, Your Honor, the state dismisses those 2 counts in exchange for the plea to the rest of the counts.
Okay. Your sentence will be the following, Mr. McGee. In 24 CF 376, adjudication of guilt, all counts. Count 1 will be 6 years Department of Corrections, 5 years on count 4, time served on count 5. Those will be concurrent. And then followed by 5 years of probation on count 6, $867 in court costs, no contact with the victim, credit for all time served. Reserve on restitution for 120 days. You also have to do the batter's intervention program, and it'll be $40 cost of supervision per month. And 24 CF 669, adjudication of guilt, 5 years DOC on count 1, 6 years DOC on count 2, concurrent with each other and with 24 CF 376, $867 court costs, credit for all time served. Anything that I've missed?
No, Your Honor.
Okay, it is a guideline sentence like I previously mentioned. Mr. McGee, I have to have you talk to probation, and then I'll need you to be fingerprinted, and you have 30 days to appeal the judgment and sentence.
Thank you.
This is Amon Robinson and 23 CF 812, 24 CF 638, 24 CF 1682. Your Honor, I did get the search warrant in this case. I would ask for a continuance. I did provide a hard drive for the cell phone downloads.
State?
No objection, Your Honor.
Hold on a second. Are there VOPs on this case?
No, sir.
So the first case is over 2 years old?
Yes, sir.
All right, last continuance, October 29th, 9 o'clock.
Yes, sir. Yeah, I do have some out of custody. Latavius Brown in 24 CF 785. He was set today for PRC. The state was looking at it for a different offer. I would ask for a continue. He is not. There's a waiver on file, Your Honor. You said that I told you I would continue. You said that would be the very last continuance, so I am asking for you to continue it.
Okay. Hold on, let me get to that case.
Yes, sir.
I did mark as last continuance. It'll be the last continuance that was
Yes, sir.
discussed last week.
Yes, sir.
October 27th at 9 o'clock.
Your Honor, next I have is Donald Couch in 25 CF 389. I do have a plea to a misdemeanor, and I believe the fingerprints had already been provided to the clerk.
Can you check on that? When were those provided? Okay, she's got them. All right, so in State of Florida versus Donald Couch, 25 CF 389, this is a plea agreement to a misdemeanor from the felony drive-on license suspended. Court will accept it. Adjudication of guilt, $300 in court costs. Credit for time served, 120 days to pay the costs. Otherwise, there will be a judgment against Mr. Couch.
Yes, sir.
And I've reviewed his signature on there. Fingerprints have already been filed.
Yes, sir.
Thank you.
Your Honor, next I have is Jeff Ledoux. Your Honor, this was at PRC as well. I ask for a continuance. If we can get it resolved, I will get it filed sooner than that. We do expect one case to be dismissed, so we will be left with one case, so we should be ready to go by next cycle.
Ready to go as far as?
Having it resolved or having a
Or
second
trial.
trial. Yes,
Okay.
sir.
This was announced as plea or continuance. It'll be October 27th at 9 a.m.
And I think that's all I have on the docket. Are we still going to do Mr. Prince's case at 12:30?
Who's that?
Connor Prince from the pretrial detention?
Yeah, I did get the motion
Are
this
we-
morning.
So that'd be 12:30, Your Honor?
That would, well, we can probably, is he here? Do we have Prince? Can we get him transported? Y'all just,
Maybe 11 or 11:30?
see when we can get him here. Are you going to be sticking around for that?
I can walk right back over if
Your Honor, the only thing, I'm going to have the investigator for Crestview Police Department to appear, so I would like to try to give her a time.
Oh, well, what do y'all want to pick? Want to just say 1 o'clock?
is it any way to do 12:30? I have to be in Walton County at 2, so I'm just
Okay.
trying to manage that time.
12:30.
Okay, we'll do it at 12:30, but I think they needed a time for the investigator to be here. So I think we said 12:30 last week, so I'm
Yes,
not
sir.
going to change it
Yes,
unless
sir.
there's a reason to. All right, we'll see that at 12:30.
Thank you.
Yes, sir. Thank you.
Let me make sure you didn't have anything else. All right, I didn't know who got here first, Mr. Cobb, Mr. Flowers? Okay. You got him set up?
I have an out of custody as well as an in custody. Which one you want me to do first? That's
Whatever you would like to do, Mr.
Well,
Cobb.
Mr. Robinson's here, so let's do him.
Okay, this is Victor Robinson.
Yes, sir, Judge. If you remember last time we were in court, I'll look at it. We talked about there being a possible video of the battery, and there is. The video was sent to me yesterday, and I have to look at it, and I'm going to ask for a continuance so I can go over the video, take it to the jail, and show Mr. Robinson. And then I believe the state and I are going to be able to resolve this case. So I'm going to ask for continuance, but if I can advance it on the docket to get it resolved, I'm going to.
State.
That is correct, Your Honor.
All right, I'll put it on October 29th at 9, but if you get it worked out, you can bring it into an earlier date.
I anticipate bringing it in early, if we can. I'm going to come down and show you the video. Okay. All right. Thank you, Mr. Robinson.
Mr. Robinson, if you could, is your jumpsuit not meant to have buttons on the front of it? Okay.
It's
a little
ripped.
much with no undershirt.
Will it do it? No, there's not a button there.
Well,
So,
we could ask the jail to give you a new one.
all right. And then I have an out of custody, Judge.
Yes.
Judge, this was placed on the docket for a clear continuance. I'm going to discuss with the state possible resolutions.
Okay.
It's a trafficking and fentanyl case, and the only thing additionally that I need to do is go over and review the affidavit of probable cause, which was delivered to me at the beginning of August. I've looked at it, and if there is an issue with regards to any type of suppression, I'll file it, but I think that we might be able to resolve it after speaking with the state a little bit.
Yeah, could we possibly set it for maybe Friday jury review? We should have a resolution.
Yes. All right, let's put it on September 25th at 9 o'clock for a possible resolution. If for some reason y'all need to well, I'm going to set it for a pretrial conference too, just in case, which will be October 27th at 9 o'clock.
Yes, sir.
So September 25th and October 27th at 9.
Yeah, we'll work towards the 25th date for resolution, of course. So,
I would bring you in earlier, I just don't really have anything else that works.
I understand. I do know that there was a client that told me her case was on the docket today. When I went to look at the docket, it wasn't. Jessica Taylor. She was in court last week, and I'd recently been appointed, and she said it got continued to today's date. Or that's what Mr. Nopes told me in the notes when he covered for me. But it's not on the docket. And I looked online to see when it had been set, and I believe it's been set already in September for pretrial.
I'm just trying to find it, if it's, you mean October?
Yeah, October, that's what I thought. It's 2025 CF 14.
Say it.
Oh, no pros. Oh, I'll definitely take that. Did I hear that correctly? Did I hear somebody say
I'm
that?
not sure that the clerk can announce a null pros.
I'll contact the state and see. I just haven't seen it updated in the clerk file.
Do you have a case number on it?
Yes, sir, it's 25 CF 14. I thought the co-defendant's case was null pros last week because the trailer had been returned, so that's why I was wondering.
Yeah, I've got those, it was null pros.
I just haven't seen the null pros filed, so I
I think
wasn't.
it was announced in open court. Anybody from the state want to respond?
It's,
Jessica Taylor, did y'all dismiss that one last week? The grand theft issue. Who was the other person involved? Do you remember?
Remember, I would say her boyfriend, but that's not going to help you.
Do you know what day that was on?
That was on Monday.
Thank you, Your Honor. I've got my dockets here so I can see what I got.
I didn't come to Jason McDonald?
That sounds familiar, yes.
Well, I'm showing it as null pros on the clerk's minutes. It was supposed to be set for today, but then it got canceled after the null pros was entered.
Hey, I'm happy for that. I'm going to just back out of here and be done with it. So that's fine. I believe that's all I have, Judge. Thank you.
Thank you. Mr. Flowers, are you ready?
Good morning, Your Honor.
Morning.
Zaniyah Brown.
Ms. Brown here.
Judge, I suspect that she is not. There's a waiver. However, we resolved the case in the form of, the state and I have agreed, and with your permission, we'll file a written plea that will dispose of the matter.
All cases?
Yes, sir.
Yes, Your Honor, it was for both cases, 2 misdemeanors, basically was for consecutive probation, a total of 2 years.
All right.
Your Honor, that's exactly what we agreed to.
Is she local?
She is.
Well, just probation's going to want to meet with her.
We'll have her, Judge, I'll have it filed within a couple of days, and I'll see to it that she goes to probation immediately upon her
Probation
signing.
have an issue with that? Immediately, otherwise, if they're not instructed, then
Not seem to be, we do written pleas all the time. I don't understand.
not to probation typically. Usually they're just kind of court costs. And
Well, I
is there a reason why
apologize.
she can't report to court to be put on probation?
There's no reason why. I mean, if you want us to come back and announce a misdemeanor plea, we'll be pleased to come back at a date certain, Judge.
I think it causes more problems than it fixes to do it that way.
To do a written plea
To
is
not
no
have
problem.
her here to be instructed by probation.
As opposed to walking right down to her office. I mean, I'll do exactly what you tell me to do, Judge.
It's not right down the street because I don't know where Miss Brown is. I haven't seen her before. This case has been pending since 2023, and I haven't seen her in court. So I'd like her to come to court to take her probation and be instructed by the probation officer who's in the court.
I'll do exactly what you say, and we'll do that, Judge.
All right, thank you, Mr. Flowers. Who else do you have?
Then when should
So
we
when
start
should I
it
have
for-
her here?
Your Honor,
Would you like to have her here?
Well, I don't want to, but I'll come whenever you say. How about the next opportunity the court has that we're doing court?
I can do Thursday or Friday this week.
I will
Friday?
be available.
Friday.
Friday at 9 o'clock for a plea to a misdemeanor.
Thank you.
We'll have our misdemeanor ready to go Friday morning, Your Honor.
All right, thank you.
Next matter is Ercard, E-R-K-A-R-D. Mr. Ercard is present, Judge. If I can review where we are in this matter. The state had and was entitled to some reciprocal discovery that we received and have sent it to the state. My records indicate in the form of some texts from the alleged victim to Mr. Earhart. I believe that we've sent those last week.
I haven't received them.
Filed as a reciprocal. I think we talked about this when Mr. Shaw covered for you the other day, and that's why we said it, just to make sure everyone
Yes,
had
sir.
everything.
Yes, sir. And we also had discussed, maybe 2 or 3 terms ago, our request to take the second deposition of the alleged victim because of information that we discovered that we brought to the state's attention. And
I took that under advisement,
Yes, sir.
given that y'all were going to talk about whatever this reciprocal discovery was.
And we did, and the state, I believe, takes the position that we shouldn't be allowed to do so. I'm not speaking for the state, but that's what they told me.
Okay, but she hasn't seen what you've provided yet.
She knows what it is, I've told her.
Well, if I may, Your Honor,
Yes.
I may know what it is, but I can also add that that information was already discussed during the first deposition of the victim. I had a conversation with her, and during the deposition, they addressed whatever text messages they're talking about. So again, unless I see them, if it's what I think it is, based on what he's representing, they've already inquired extensively with the victim about that during the first deposition. It was a 2 hours deposition.
During the 2 hours, it was never discussed.
Y'all have transcripts?
Yes.
Have y'all looked?
The questions I want to ask have never been asked.
Again, the whole point of turning it over is so that the state could actually review it.
Which is why we did
When was it turned over?
last week.
The only
Judge,
thing you were-
while I come up here Friday, I'll hand deliver it once again, if that would be helpful.
Well, I would like for it to be reviewed before then, if that's what we're going to do, but
I'll bring it tomorrow. I'll bring that which has been delivered already back tomorrow. I agree with your assessment, Your Honor. I want them to have it.
let's bring it back Friday the 5th, 9 o'clock.
Thank you.
So we'll be back here Friday, Your Honor.
Let's have an idea. I mean, if y'all look at it and you have some sort of an agreement, otherwise I'll make the decision on Friday.
Okay.
But
Yes, sir, I
the
understand.
motion for the new depositions is based on evidence. I don't know what it is, and the state hadn't seen it yet. So that was the only reason I was reserving on it, so I knew if it was a worthwhile endeavor. But what I'd like to know, based on what I've heard today, is were those depositions in existence, or the text messages you're talking about, were they available at that deposition?
Understand.
Because not asking certain questions that you would have asked now, I'm not sure is sufficient if that information was available to his prior counsel.
Understand.
But y'all talk about it, and we'll talk about it on Friday the 5th.
Yes,
Very
sir.
well.
Thank you.
Yes, sir, I understand. Next matter is Frazier. I believe that's with Mr. Sheik. Did we have it? Your Honor, I had advised Mr. Sheik, and he agrees that this case is not ready to proceed. We're asking that it be continued. It's my understanding that the state does not object to that occurring.
Is this the one with the
Correct.
accident reconstruction? Do y'all
Yes, sir.
have your experts all listed and ready to go?
We're seeking to hire one. It's a funding scenario at this time, Judge.
All right. Let's put them on 10/27 at 1 o'clock. Mr.
Yes, sir.
Clerk. All right,
Thank
we'll
you.
see you back on that day.
Yes, sir. Final matter I have is Wise, State v. Wise.
And that's 24 CF 1362.
Yes, sir, and this is, I think, a 2016 allegation. In there, can we approach on that, Your Honor, so I don't misspeak?
We're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
Circumstances that are a little bit unique in discovery that the defense is asking for, and the state doesn't object to this matter being continued.
That's correct, Your Honor.
Okay. All right, it'll be 10:27 at 9 o'clock.
Your Honor, that's what I have. Thank you, sir.
Thank you, Mr. Flowers. Have a good day.
Judge, this is going to be Daniel Endicott. Case number for the record is 25 CF 717, and we have a plea agreement. If I can have a second. Judge, this is going to be a plea to a misdemeanor, so there's not going to be a score sheet. May I approach?
Endicott, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do, Judge.
All right. Can you state your name and date of birth, please?
Daniel W. Endicott, 1/6/1980.
Okay, and Mr. Endicott, you're here in 25 CF 717, where you're currently charged with felony criminal mischief, which is punishable by up to 5 years in state prison. Do you understand that?
Yes, Your Honor.
Now, the plea and sentencing agreement I've been handed would have you plead no contest to lesser included criminal mischief of a second-degree misdemeanor, 806.131A and B1, being adjudication of guilt, 60 days county jail, credit for all time served, court costs would be $270 on a misdemeanor, $100 PD fee. Those will go to judgment, and there's no restitution owed. Is that the state's agreement?
It is, Your Honor.
Is that what you want to do today, Mr. Endicott?
Yes, Your Honor.
All right. And have you gone over this form with your lawyer?
Yes, I fully understand it, Your Honor.
You understood and signed it too?
Yes, Your Honor, I did.
Okay. And are you happy with your lawyer's advice and representation?
Yes, Your Honor.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, Judge, I'm not.
Are you currently suffering from any mental health issues?
No, Judge.
Has anyone forced, pressure, or threatened you in any way to enter this plea?
No, sir.
And has anyone promised you anything in return for your plea?
No, Your Honor, only the agreement on the paper.
Thank you. And do you understand by pleading no contest, there won't be a trial of any kind, and you're giving up your trial rights, which are on page 2 of that agreement that you signed?
Yes, Your Honor, I comprehend that.
All right. And you understand you're waiving all potential defenses?
Yes, Your Honor.
And do you understand that if you're not a U.S. citizen, this could lead to your deportation?
Yes, Your Honor, I understand.
Got to ask everybody. And what is your plea to the second-degree misdemeanor criminal mischief?
To the misdemeanor is guilty. Plead guilty, sir. Okay. What time?
It says no contest on your form.
No contest. I'm sorry.
Okay.
I apologize.
That's fine. I just want to make sure that there wasn't any conflicting evidence on here. So, all right. I'll accept your no contest plea as freely, voluntarily, knowingly given to criminal mischief, second-degree misdemeanor, 806.131A and B1. Adjudicate you guilty, 60 days jail, credit for all time served, court costs of $270, $100 PD fee. Those will go to judgment against you, and no restitution is owed. All right. Thank you, Mr. Endicott. You've got 30 days to appeal.
All right. Do I get to keep that plea agreement?
They can get you a copy, but the original has to go in the court file.
It'll be filed. Judge, I do have one out of custody, if I could call her, Ms. Lemon, Daniqua Lemon. Present and approaching judge, case number is 24 CF 2165. Ms. Lemon's case, Judge, we had deposition set for Friday. Two of the civilians had, one was unavailable and one had to go to a funeral, so we excused her, so we'll need to reset those.
I think we talked about that last week.
Yes, sir. At this time, we're going to ask for a continuance to the next pretrial conference so we can get those two depositions taken.
State have any issues?
No issues from the state.
All right. All right, Ms. Lemon, we'll have you back on October 27th at 1 p.m. for your next pretrial conference.
Thank you, Judge.
Thank you. Mr. Kleins?
We'll just go in order. I don't have that many. I do have Bradley Anderson in the gallery first, to be followed by Mr. Kelvin Brown in custody. Your Honor, as Mr. Anderson approaches, a week ago from this past Sunday, Ms. Leone extended Mr. Anderson a plea offer that would not involve a Department of Corrections sentence. I talked with Ms. Leone last week, and I frankly requested her to leave that offer open until the end of September. She has graciously accepted that request. I am going to ask the court to continue Mr. Anderson's cases today. However, that plea offer that the state has made to resolve both of these felony cases, and it frankly probably would most likely resolve 2 misdemeanor cases that he has also. That offer will expire before September 30th. I have instructed Mr. Anderson to call my office, make an appointment so we can sit down before the middle of the month, if at all possible, and go over the evidence to see how he wants to proceed. The intent would be, if he accepts the offer, to get him on the first available pretrial docket for entry of a plea if he accepts it. But he is aware that the offer that the state has currently made does expire on September 30th.
So I would say after this week, the only other date I'll have before September 30th is the 25th.
Understood. And
Y'all
yes,
want to
sir.
go ahead and set it on that date just to make sure you get in before the 30th?
Sure. If we can set this for September 25th.
I mean, I'll give you a new pretrial date too, just in case y'all continue that or cancel it.
That's fine, Your Honor.
All right. So what I'm going to do, Mr. Anderson, based on what you've heard your attorney announce, is I'm going to put you on my September 5th docket at 9 a.m. That's a miscellaneous docket where you can enter your plea. If you don't intend to enter a plea and y'all cancel that date, it would then be October 27th at 9 o'clock.
And that's September 25th, correct, Your Honor?
What did I say?
The 5th.
I did.
Yes.
I appreciate you correcting me. September 25th.
Okay.
September 5th is one I've announced already several times a day and just starts to just roll off.
I know. I totally
appreciate
understand. You also have court with me on the 15th. Call my office, make that appointment. Your Honor, this is Mr. Kelvin Brown. We were not able to get a resolution to resolve Mr. Brown's situations here. I will tell the court there's 3 individuals that I'm representing today. The issue is their score sheets. Mr. Brown is one of them. Mr. Hainish and Mr. Paris are the other 2. We are working with Mr. Sheik to try to resolve these cases. If I can get Mr. Brown, I don't want to ask the court to put him on for Friday because I don't want to clog up the docket for no reason unless we have a definite plea or something.
If you have it, you can put it on Friday, but we're not going to do that today.
Absolutely. No, that's what we're shooting for. And I told Mr. Brown, I said, look, we're going to technically continue this to the end of October, but if I can get you back in court before the end of the week, that's my goal.
Just make sure if you're going to try to put on this Friday, you do that no later than noon on Thursday.
Yes, sir.
So it makes it to the docket and everyone knows it's going to be there.
Absolutely.
All right. Next pretrial will be October 27th at October 29th at 9 a.m. But you can put it on a sooner date if needed, Mr. Kleins.
Okay. All right, Kelvin. I'll come see you. Next I have in the gallery, Your Honor, I have Ashley Cook, followed by Cynthia Gallardo. And Ms. Cook is present and approaching. I talked with Mr. Sheik this morning, Your Honor. We have attempted to take the deposition of the alleged victim in this case at least one time. He's not been found. I said that we were ready for trial last week. I remain ready for trial. However, I'll turn it over to Mr. Sheik to fill in.
So, Your Honor, we have subpoenaed the victim in this case for Friday. And so we just ask that, because in that situation, I don't think either of us would be ready if the victim does show up. However, the state is ready to dismiss the case on Friday if they don't. But if they do, we would.
Have they been served?
They have been served. Well, We sent the service out last week. I can't guarantee because it wasn't until last week. I should know in the next day or so whether they've successfully been served, Your Honor. But we're asking that at least so the officers and stuff, I don't have them on standby.
Just kind of recap it. If the victim shows up on Friday, y'all want to talk to that person, but neither of you would be ready for trial if that person shows up. If he doesn't show up and has been served, the state's going to dismiss the case?
Yes, Your Honor.
Okay, so we're not keeping it on the trial docket for any reason?
That's correct.
We're just leaving it on for Friday to see if he shows up, he or she?
Yes, Your Honor.
Yes, sir.
All right. All right, Ms. Cook, we'll see you back on Friday, this Friday, the 5th at 9 o'clock. Obviously, I'll figure out anything in advance. Just file what you need to.
Yes, sir.
Thank you, Your Honor.
Thank you, Ms. Cook.
Next, Your Honor, I have Cynthia Gallardo, and she will be followed by Mr. Donald Hainish. Your Honor, this is Ms. Gallardo. We have an agreement with the state to resolve this case. At this time, Ms. Gallardo is going to be entering a no contest plea to the lesser included offense of possession of paraphernalia. The agreed upon disposition is that she will be sentenced to time served. She would be assessed a $100 cost of defense. I would ask the court to impose misdemeanor court costs. I did not write the specific amount. I think it's $275, but I don't want to be incorrect. She would be adjudicated of the misdemeanor. May I approach?
Oh, yes. I was about to ask you if you had a written plea. I assumed you did, but. Cost of defense still be 150?
Actually, that's a good question. It probably should be 100.
I think it's just 100
It should
as
be
a
50.
misdemeanor.
Yes, sir. Thank you for that.
The court cost would be 270. All right, Ms. Gallardo, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Sir.
Can you state your full name and date of birth, please?
Cynthia Michelle Gallardo, 12/22/1974. I'm sorry.
All right, Ms. Gallardo, you're here in 24 CF 2930, where you're currently charged with possession of a controlled substance, third-degree felony. Do you understand that?
Yes, sir.
I've been handed a plea and sentencing agreement that would have you plead to a lesser included offense of possession of drug paraphernalia, first-degree misdemeanor. Terms of that agreement between you and the state is time served, $270 in court costs, $100 cost of defense. I'd be willing to give you 90 days to either pay that or set up a payment plan. Otherwise, it'd be a judgment against you.
Yes, sir.
Okay, is that what you want to do?
Yes, sir.
Is that the state's agreement?
It is, Your Honor.
All right. And Ms. Gallardo, did you go over this agreement with your lawyer?
Sir.
Did you understand and sign it?
Yes, sir.
Are you satisfied with your lawyer's advice?
Yes, sir.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Currently suffering from any mental health issues?
No, sir.
Anyone force, pressure, or threaten you to enter this plea?
No, sir.
Anyone promise you anything in return for your plea?
No, sir.
Do you understand if you enter a plea, you begin up your right to a trial, and your trial rights, which are on page 1 and going on to page 2 of the agreement that you signed?
Yes, sir.
And do you understand that you're waiving all potential defenses?
Yes, sir.
Do you understand if you're not a U.S. citizen, this could lead to your deportation?
Yes, sir.
And what is your plea to the lesser included misdemeanor of possession of paraphernalia?
No contest.
I'll accept your no contest plea as freely, voluntarily, knowingly given. What's paraphernalia? 893.147?
No, I spaced on that, Your Honor.
I'm not sure if we're going to need a number. No, I mean.
It's 893.147.
Yeah, but it usually need a subparagraph. You don't need one on this one. I said the number. It'd be time served, $100 cost of defense, $270 in court costs, 90 days to either pay those or set up a payment plan. Otherwise, it'll be a judgment against you. Ms. Gallardo, it's an adjudication of guilt.
Yes, sir.
I don't think I need anything else from you other than to tell you you have 30 days to appeal the judgment and sentence of the court.
Okay. Thank you.
Good luck.
Make sure you set that up with the clerk.
It's Mr. Hainish. He has 2 cases, 24 CF 1021, 25 CF 146. With Mr. Hainish, the score sheet is even more of a problem than it is with Mr. Brown. I would ask the court to continue this one cycle. We are working on a resolution. If I can get the state and Mr. Hainish on the same page, we'll advance it on the first available document.
You understand that, Mr. Hainish?
Yes, sir.
put you on October 29th at 9 o'clock for your next pretrial conference, but if they get it worked out and want to bring you in early, I'll accept that as well.
Next, I have in the gallery, Tony Henderson. I believe Ms. Henderson was continued over from last week. I have not had contact with Ms. Henderson. And to remind the court, I believe what happened was Ms. Henderson somehow slipped through and was on the afternoon docket last Monday. I was not here in the afternoon, so I didn't even talk to Ms. Henderson last week. I think the court just probably put this on for today, but I don't know if she was here last week.
Was. I'm showing that she appeared without counsel. I told her to come back September 2nd at 9 a.m.
I would ask for a capious with a bond, possibly.
That's what I was thinking.
Are you done?
All right. Capious with a $2,500 cash or professional bond per count for a total of $5,000. Obviously, if she contacts you, Mr. Kleins, and there's some sort of miscommunication, but I believe I instructed her to be back last week. But I'll consider withdrawing the capious if you can get her into court.
Oh, if I can get her here on Friday, I will.
Oh, was there only one case?
That's all I.
One
Oh,
count,
I'm sorry.
yeah.
Or not one case, one count.
Yeah.
So it'll be $2,500 for the one count.
I signed on the wrong spot.
Yeah, he signed on the wrong spot. So
Okay.
just go ahead and sign down here. Your Honor, this is Mr. Kelly. He is signing a plea agreement now to resolve this case with the state. Today is 9/2. At this time, Mr. Kelly is going to be entering a no contest plea as charged. The agreed upon disposition is that he will be sentenced to time served on counts 1 and 2 concurrent. He would be assessed $615 in court costs, $150 for the cost of defense, and he has previously been adjudicated. He will be adjudicated. May I approach?
Yes, sir. Thank you. All right, Mr. Kelly, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
All right, can you state your full name and date of birth, please?
Travis Russell Kelly, 7/27/1992.
All right, Mr. Kelly, you're here in 25 CF 1035, where you're currently charged with third-degree felony possession of controlled substance and first-degree misdemeanor possession of drug paraphernalia. Do you understand that?
Yes, Your Honor.
I've been handed a plea and sentencing agreement that would have you plead as charged. Credit for time served. Your sentence would be concurrent, $615 court costs, $150 cost of defense, and then I would give you 90 days to set up a payment plan to pay those costs after you get out of jail. All right, is that what you want to do?
Yes, Your
And
Honor.
you'd be adjudicated on both.
Okay.
All right. So that's a felony conviction on the possession. Do you understand that?
Yes, Your Honor.
All right, possession of controlled substance, that is. All right, did you go over this plea and sentencing agreement with your lawyer?
Yes, Your Honor.
Did you understand and sign it?
Yes, Your Honor.
Are you satisfied with your attorney's advice?
Yes, Your Honor.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, Your Honor.
Are you currently suffering from any mental health issues?
No, Your Honor.
Has anyone forced, pressured, or threatened you in any way to enter this plea?
No, Your Honor.
Has anyone promised you anything in return for your plea? You understand by entering a plea of no contest, as indicated by your plea form, that there won't be a trial of any kind and you're waiving your trial rights?
Yes, Your Honor.
Do you understand you're waiving all potential defenses you may have?
Yes, Your Honor.
And do you understand that if you're not a U.S. citizen, this could lead to your deportation?
Yes, Your Honor.
And what is your plea to the possession of controlled substance and possession of drug paraphernalia?
No contest.
I'll accept your no contest plea as freely, voluntarily, knowingly given. Sentence you for credit for time served on both cases, or both counts, excuse me, $615 court costs, $150 cost of defense. I'll give you 90 days from the date of your release to either pay that or set up that payment plan. This is a guideline sentence. I've reviewed the guidelines where you scored 29.6 points, so you didn't score prison. All right. I need you to be fingerprinted, and then you have 30 days to appeal the judgment. And
Thank you, Your
sentence
Honor.
of the court.
Good luck. Thank you, Mr. Pine.
Thank you.
Your Honor, can we approach on Mr. Paris real quick?
Sure.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
All right, Mr. Paris, this was announced as plea or continuance. I'm going to put you on October 29th at 9 o'clock. My understanding, there may be a little bit of a score sheet issue they're trying to work out for you. If that's done ahead of time, y'all work something out, you can come in at an earlier date than that. Mr. Kleins will set that up.
And, Your Honor, I filed the null pros in 24 CF 2738, but I just wanted to announce it in court. The defendant is not the individual who took the property in that case, Your Honor.
All right, so 24 CF 2738 is dismissed or null pros by the state, but we'll put the other cases on for October 29th, 9 o'clock.
Thank you, Your Honor.
I believe that's all I have, Your Honor, if I may be excused.
Yes, sir.
I'll see you Friday morning.
Your Honor, this is Justin Peacock, 23 CF 2819. We've reached agreement in this matter, if I may approach.
You know, I have an agreement last time, just trying to figure out how it's going to work.
Yes.
I just seem to remember Mr. Peacock coming up several times last time. All right. All right, Mr. Peacock, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes.
All right. And your name and date of birth, please.
12/13/85, Justin Del Peacock.
All right. Mr. Peacock, you're here in 23 CF 2819, where you were charged with possession of ammunition by a convicted felon, second-degree felony, punishment up to 15 years in state prison. Do you understand that?
Yes, sir.
All right. I've been handed a plea and sentencing agreement. I know we went over one last week, and then looks like we've kind of hammered out the details here to make sure it's not confusing.
Yes, sir.
Okay. It would have you plea as charged. You'd be put on 11 months, 29 days of administrative probation. Probation may terminate early upon the completion of 11 months, 29 days jail in the Okaloosa County Jail, and the compliance with the Emerald Coast Life Center as part of that jail sentence. According to the plea agreement, you entered that program on August 25th, so that would be the start date of your sentence.
Sure.
As far as the jail goes. Otherwise, your credit for time served before August 25th would be waived. Do you understand that?
Yes, sir.
And so just to make sure we're all clear, if he gets out earlier than 11/29 because of gain time in compliance with the program, then his probation would be over, right? State's agreement?
Yes, sir.
All right, just wanted to make sure, because I think that was part of the hiccup last week. All right, also, 515 court costs, $100 PD fee, $50 application fee, which will all be reduced to judgment. Is that what you want to do, Mr. Peacock?
Sure.
All right. Did you go over this plea and sentencing agreement with your lawyer?
I did.
Did you understand and sign it?
Yes, sir.
Are you satisfied with your lawyer's advice and representation?
Yes, sir.
You said yes?
Yes.
Okay. Are you currently under the influence of any alcohol, drugs, or controlled substances?
No.
Are you currently suffering from any mental health issues?
No.
Have you been forced, pressured, or threatened in any way to enter this plea?
No.
Have you been promised anything in return for your plea?
No.
You understand if you enter a plea, there won't be a trial of any kind?
Yes.
Do you understand that you're also giving up your trial rights, which are in the agreement that you signed?
Yes, sir.
And do you understand that you're waiving all potential defenses that you may have?
Yes.
And do you understand if you're not a U.S. citizen, you could be deported
Yes.
based on this case?
Yes, sir.
And what is your plea to the possession of ammunition by a convicted felon?
No contest.
Let me just make sure, 'cause I think this might have been one of the issues too, is that you understand even if you're on administrative probation, if you were to commit a new law violation or violate your probation anyway, that you could be violated, and the state could seek, and the court could sentence you to up to the maximum of the 15 years.
Yes, sir.
For example, if there was a battery on a detainee or a corrections officer charge that came up, it could violate your probation. This is not just 11/29 with time served.
Yes, sir.
Okay, just want to make sure that you understand all that. All right. And it was a no contest plea, correct?
Sure.
All right, I'm going to accept your no contest plea. It's freely, voluntarily, knowingly given. Put you on 11 months, 29 days of administrative probation. Probation may terminate early upon completion of the 11-month, 29-day Okaloosa County Jail sentence in compliance with ECLC. That start date of the jail time will be August 25th of 2025, so your credit for your time served begins on that date. Previous credit would be waived for purposes of this plea. 615 court costs, $100 PD fee, $50 application fee. All costs will be reduced to judgment. This is a guideline sentence in that there was 32.8 points. Anything that I missed? All right. I think you still need to talk to probation, even though it's administrative, and you probably, if everything goes right, wouldn't have to report. Okay.
Thank you.
Hold on just one second. The jail time is a condition of that administrative probation. All right, I need to be fingerprinted, Mr. Peacock, and you have 30 days to appeal the judgment and sentence. Oh, I thought you were letting them go through. I'm like, you just...
Your Honor, this is Richard South, 23 CF 1796. We're ready for trial.
All right, state ready?
Yes.
Anything we have to talk about before Friday?
No, in this case, Your Honor, I would ask the second week
issues with that? Ms. Rivers?
No, Your Honor.
Y'all still want to bring it back for Friday, though, right?
Yes, Your Honor. I do believe that I will be filing a motion in limine.
Is it more than just kind of a typical boilerplate?
It's typical boilerplate, Your
Okay.
Honor. It's
Well-
based on depositions.
Okay. So if you could get that over to Ms. Leone before Friday so she can review it to see if we have to have a hearing on that.
Yes.
All right, so Mr. South, we will have you come back on Friday, the 5th this week. And then we expect your jury trial date would be, what is that, the 18th? 18th. All right, we'll see you back on those days.
Thank you, Your Honor.
You're welcome.
Your Honor, this is Chayton Trulove before the court on 24 CF 60. In speaking with the state, we are going to put this on 9/25, and we will get all the terms hammered out before then.
For a plea?
Yes, Your Honor.
As a plea and a sentencing, the victims would like to be present and may just wish to address the court, but it'll be an agreed-upon plea.
All right, September 25th, 9 o'clock for purposes of a plea. I'm still going to give it another pretrial date just in case. October 29th, 9 o'clock.
Okay.
All right, we'll see you back on September 25th.
I would like a copy of that too.
Okay. Your Honor, this is Richard Wagner before the court on 23 CF 2526, 25 CF 894, 25 CF 895, 25 CF 898, 25 CF 899, 25 CF 902. So, Your Honor, we are leaving these cases set for trial.
Well, Your Honor, we discussed the 23 CF case. Yes, for either week is fine.
So 23 CF 2526 will be set for trial. I believe the other remaining cases will be continued to the next pretrial conference, but not at the defendant's request.
Correct.
And I did file that motion to compel the defendant to give fingerprints.
Okay,
I did provide that, Your Honor, to my client.
okay. Do we have to have a
If he could,
hearing on that?
He would like his hearing.
Okay, we'll have it later this afternoon, later today.
Okay.
yes.
All right, make sure we keep him.
Sure? Okay. No. Mm-hmm. Go give him a tour now.
Well,
He is,
there-
he's willing to give him, Your Honor.
Okay, well, let's make sure it's clear then. Can we move Mr. Walterman so he can come back? Because I want to make sure this is on the record. Mr. Wagner, if you can go back to the, I want this to be clear. So, Mr. Wagner, the state has filed a motion in the 23 CF 2526 case to compel your fingerprints. You had initially objected. Sounds like you've now said, at least to court security, that you don't want to object and give your fingerprints now. Is that correct?
Yes, sir.
All right, so you no longer have any objection to the motion to compel your fingerprints? All right, based on that, he'll be fingerprinted before he leaves and be fine to be transported back. For the other cases, it'll be October 29th at 9 o'clock for her pretrial conference. Yes. September 5th for Mr. Wagner for jury review.
Your Honor, this is Jason Walterman, 24 CF 1518. Your Honor, last time we were in court, there was a discussion about Mr. Walterman would like to represent himself.
All right, well, then we'll bring him back for a FREDA hearing. I want to get through the rest of the docket before we do that because it's time consuming. All right, Mr. Walterman, we'll bring you back up a little bit later today to go through the FREDA hearing. I just don't want to spend 15 minutes on that while I've got all these other people waiting. So it'll be later this morning.
Your Honor, there were two other out-of-custody people to address, and that is Donald Simmons. He is present and approaching, 25 CF 703. In this case, Your Honor, we had listed an additional witness. The state would like to depose that witness. We're in agreement with a continuance to the next pretrial cycle, which would be the October 27th.
That is correct, Your Honor.
Okay, I think we talked about this as being a possible continuance.
Yes, Your Honor.
All right, so 10/27 at 1 p.m. for your next pretrial conference. Mr. Simmons, be back on that day.
Yes,
Stay in
sir.
touch with Ms. Rivers so they can get that deposition done.
Yes, sir.
All right, thank you.
Thank you again. Call you. He tried to call you.
And
Yeah, okay.
Rebecca Thomas, 24 CF 937. Your Honor, we did receive a call from Ms. Thomas. My assistant did. Oh, there she is. She did make it. She was having car trouble, Your Honor. Your Honor, she previously entered a PTI in this matter. So this has come back on a failed PTI. She did enter a plea, a no contest plea to the charge. So today would be sentencing. She's not asking. It's the same as before. So it'd be adjudication withheld, same thing.
Have y'all talked with the state about a possible resolution or no?
Yes, Your Honor.
Been any sort of agreement or?
The same terms and conditions of the PTI, Your Honor. It would be an adjudication withheld and she'd be placed on probation with the same terms and conditions.
Make sure I understand what those are.
Yes, Your Honor.
So I'm looking at the pretrial intervention agreement that was filed on September 13th of 2024 that requires her, or she agreed to participate in FFN services, be subject to no notice urinalysis testing, refrain from any law violation. Let's see. Problem is, the defendant agrees that she will participate in and pay for programs established under her supervision of the DOC. So,
And
were there actual things that were ordered to be or requested to be done?
no, Your Honor.
All right. What's the state asking for as far as the conditions, just so I make sure they're clear?
Your Honor, she was originally required to participate with Families First Network. And there was a plan in place, and that is what we were requiring her to participate in. It's our understanding that she was unavailable for pretrial services supervision. I'm sorry, for supervision, and had not completed anything. If we need more specifics than that, I'll have to get the plan.
I think my concern is if I'm putting in a probation and ordering what she has to do, if it's not clear, there could be problems with potential violations. I don't want her to be violated because there's some ambiguity, or I also don't want it to be a situation where the defense is the ambiguity. So I just want it to be a little more clear.
If the court wishes to reset this for Thursday, we can get that, or?
All right, can y'all approach?
Backbone Bakery Cafe is 2 blocks from the courthouse on Crestview historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by.
I'm Amanda Gaskin with Briarpatch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
You've been injured in an accident and need righteous representation? Call us, because we fight fire. Damn thing ain't working.
Not
cool, bro.
So
I'm
what we're
Attorney
going to
Coy
do, Ms.
Browning.
Thomas,
Personal injury is
I'm
no
just
joke.
looking through records on your other case. There seems to be, we're not clear on what was done and what wasn't through that case, which was basically part of your PTI. So we're going to have you come back Thursday at 2 o'clock in the afternoon so that everyone can verify what's been done. I've been able to look through the records of your other case. I just want to make sure there's no other issues. So we can fashion a proper sentence for you or determine whether or not you've actually completed your PTI. All right, we'll see you back on Thursday.
All right, thank you.
All right, do you have someone else, Ms. Rivers? Okay. Mr. Maddox?
Yes, Your Honor. Do you want me to call the out of custody first?
However you want to call them.
Go ahead.
If you want to get the out of custody people out first, or just do it straight down the list.
Yeah, I'll go ahead and call the out of custody if that's all right, Your Honor.
All right, go ahead.
Justin Nolan.
What's the big idea with this? Okay, I don't recognize him. Go ahead.
Your Honor, this is Mr. Nolan. He's present and approaching 25 CF 661. We had this down for plea or continue, Your Honor. We're going to continue the case today.
All right, Mr. Nolan, we'll see you back October 27th at 1 p.m. for your next pretrial conference.
Sure.
All right, stay in touch with Mr. Maddox.
Thank you, Your Honor. Your Honor, next up I have Ms. Cheyenne Dow, 24 CF 2538. Your Honor, Ms. Dow is present and approaching. State's made an amended offer in her case, Your Honor. I just need to go over that with Ms. Dow.
You want to do that today?
No, Your Honor, only because it's going to require significant more involvement on her part. It would be another PTI. I need to go over all those terms with her, Your Honor. She did have some additional questions.
All right, so what are you asking for?
A continuance, Your Honor. I do believe we'll have a resolution, though.
All right, Ms. Dow, come back on October 27th at 1 o'clock.
Susan Tintle, Your Honor. I guess we can do that one last. She's on Zoom.
I can pull up Zoom.
Okay.
Why don't you call one more while I do that?
Yes, Your Honor. Dial on Dickerson. Mr. Dickerson's present and approaching, Your Honor, 25 CF 909. Same situation with Mr. Dickerson, Your Honor. He has some additional questions about the amended offer from the state. I would ask for a continuance in this case, Your Honor, but I do anticipate resolution.
October 27th, 1 o'clock for your next pretrial. I think this was the first cycle.
I think it's the second, Your Honor.
Okay. All right, we'll see you back on October 27th at 1 o'clock. Mr. Dickerson, stay in touch with Mr. Maddox.
All right, sure thing, man. I'll give you a call. Heather Graves, 22 CF 455. Your Honor, we have reached a resolution in this case. This is Ms. Graves. She is present. It's going to be a pretrial intervention agreement, Your Honor, with a plea. If I may approach.
Yes. I don't see anyone on Zoom yet. I'm not sure if Ms. Tintle is going to be on Zoom or not. Just might want to check with her.
I certainly will, Your Honor.
Because I don't see anybody in the room.
I will say, though, for the court, our stack is down. The public defender's office has experienced some sort of hack, is my understanding, Your Honor, so we did have to shut down our stack. I'm not sure if my staff will have her number immediately available to them. And, Your Honor, we did, in Ms. Tintle's case, we just needed to inform her that instead of doing a pretrial intervention agreement, what we're going to do is a deferred prosecution agreement where she will complete a rehab program.
Okay.
She's currently in the rehab program.
Out of state, right?
Sorry, Your Honor?
Out of state?
Yes, Your Honor.
What do y'all want to set it for then?
She should be easy to get in touch with, Your Honor. If we could just set basically a status date to make sure the DPA paperwork gets filed for September 25th.
All right, September 25th, 9 o'clock for status on the DPA.
Thank you, Your Honor.
All right, let me get this all back. Ms. Graves, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, can you state your full name and date of birth?
The Regina Graves, my date of birth is 85.
Ms. Graves, you're here in, is this? It's 22 CF 455. Was this a PTI recall?
It
or-
was, Your Honor.
Okay.
PTI recall, the first one was without a plea. This one is with a plea, Your Honor.
Okay. All right, Ms. Graves, you're here in 22 CF 455, where you're currently charged with grand theft, a third-degree felony, punishable by up to 5 years in state prison. Do you understand that?
Yes, sir.
All right, I've been handed a plea and sentencing agreement that would require you to complete the PTI program. Otherwise, you go straight to sentencing. Do you understand that?
Yes, sir.
Have you gone over this plea and sentencing agreement? Did you understand it?
Yes, sir.
And is that what you want to do today? All right, and are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Do you have any mental health issues currently affecting you?
No, sir.
Has anyone forced, pressured, or threatened you in any way to enter a plea?
No, sir.
Has anyone promised you anything for making the plea?
No, sir.
You understand if you enter a plea, there won't be a trial of any kind?
Yes, sir.
And that if you don't complete successfully the pretrial intervention, you go straight to sentencing?
Yes, sir.
At which time the state could seek and the court could sentence you up to the maximum of 5 years in state prison?
Yes, sir.
All right. And you understand you're giving up your rights to trial, which are listed on page 2 of your agreement?
Yes, sir.
And you understand you're waiving all potential defenses?
Yes, sir.
Did you read and understand the pretrial intervention agreement?
Yes, sir.
Did you go over that with your lawyer as well?
Yes, sir.
Any questions about that? So basically, it looks like you got a lot of restitution to pay.
Pretty much.
Yeah. How long is the,
36-month agreement, Your Honor. We did contemplate that there would be some needed time, a buffer period, if you will, for probation to make sure she has paid the restitution. So those payments are set out for 33 months to be completed. That way she has the 90 days so that probation can assess her compliance.
all right, is that the state's agreement?
It is, Your Honor.
All right, Ms. Graves, then what, based on the PTI agreement as part of your plea, what is your plea to the grand theft?
No contest.
All right, I'll accept your no contest plea is freely, voluntarily, knowingly given. Require that you complete the pretrial intervention program, otherwise you'll come back for sentencing. If you do complete the pretrial intervention program, your case will ultimately be dismissed and your plea withdrawn. Do you understand that?
Yes, sir.
All right. Mr. Max, if you could take that back and give the original to probation. All right, make sure you talk to them before you leave, Ms. Graves.
Thank you.
And we'll put it on to the September 25th at 9 o'clock just for status to make sure all that paperwork got filed and signed.
Sir.
Or signed and filed, I guess. All right.
All right, thank you, Your Honor. Next, Your Honor, I have yeah, I'll fix it. I don't. David Singleton, Your Honor, 25 CF 283 and 25 CF 282. Your Honor, there's a waiver on file for Mr. Singleton. If we could just set him for September 25th, there'll be a plea.
All right, so there was a new plea offer, or you just had to convey it?
New plea offer, Your Honor, that I need to convey to him, yes, sir. But I've talked to him about the possibility of this plea offer. It's basically a counteroffer of ours, and the state is amendable to it. So we will bring it home, Your Honor.
All right, I'm going to set it on September 25th at 9 a.m. for a plea, but I'm also going to give him an October 27th, 1 o'clock pretrial conference.
All right, thank you, Your Honor. Corey Kreider, 25 CF 177. Mr. Kreider's present and approaching, Your Honor. Your Honor, we've reached an agreement. It'll be a pretrial intervention agreement with a plea, if I may approach.
Mr. Kreider, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, can Can you state your full name and date of birth?
Corey Lane Kreider, April 13th, 1989.
All right, Mr. Kreider, you're here on 25 CF 177, where you're charged with 2 counts of possession of a controlled substance, third-degree felonies punished by up to 5 years in state prison each, and possession of drug paraphernalia, which is a 1-year maximum on a misdemeanor first degree. Do you understand that?
Yes, sir.
I've been handed a plea and sentencing agreement that would have you enter a plea as charged. You'd be required to complete the pretrial intervention agreement that I've been handed. If you fail to complete that agreement, you'll come back to the courts for sentencing, where you can get as much as 11 years in custody. Do you understand that?
Yes, sir.
All right. And if you complete that program, your plea would be withdrawn and the case would be dismissed. Do you understand that?
Yes, sir.
Is that what you want to do today?
Yes, sir.
All right. Have you gone over this plea and sentencing agreement with your lawyer?
Yes, sir.
Did you understand and sign it?
Yes, sir.
Are you happy with your lawyer's advice and representation?
Yes, sir.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues?
No, sir.
Has anyone forced, pressured, or threatened you in any way to enter this plea?
No, sir.
Has anyone promised you anything in return for your plea?
No, sir.
Do you understand by entering a plea there won't be a trial of any kind and you're giving up your trial rights, which are on page 2 of the agreement that you signed?
Yes, sir.
And do you understand you're waiving all potential defenses you may have?
Yes, sir.
All right. And what is your plea to the 2 counts of possession of controlled substance and 1 count of possession of drug paraphernalia?
No contest.
All right. I'm going to accept your no contest plea. It's freely, voluntarily, knowingly given. You're going to complete the pretrial intervention program. If you fail to do so, you'll come back to court to be sentenced up into including the maximum. Otherwise, if you finish the PTI program, then your case will be dismissed as your plea will be withdrawn. Any questions about that?
No, sir.
Okay. Again, Mr. Maddox, I'm going to hand you back the pretrial intervention agreement original so you can give that to probation. I'm going to put you on September 25th at 9 o'clock just for purposes of status to make sure all that paperwork's been signed and filed with the court.
Okay, yes, sir.
Excuse me.
Priscilla Dean.
Yes.
All right.
All right.
Your Honor, this is Miss Priscilla Dean before the court in 25 CF 635. I was just briefly going over with Miss Dean. She signed a plea agreement. I did add no contact with the victim with respect to the charges, Your Honor, and she's agreed that to comply with that, if I may approach.
So it's a total of 6 months probation.
Yes, Your Honor.
All right. Ms. Dean, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes.
Can you state your full name and date of birth, please?
Priscilla Dean, July the 29th, 1968.
All right. Ms. Dean, you're here in 25 CF 635, where you're currently charged with domestic violence battery by strangulation, which is a third-degree felony punished by up to 5 years in prison, and simple assault, which is a second-degree misdemeanor, punished by up to 60 days in county jail. Do you understand that?
Yes.
I've been handed a plea and sentencing agreement that would have you plead to a lesser-included offense of misdemeanor battery. On count 1, that would be 784.03. 111.
1A1, Your Honor.
1A1. I was going to say I've never seen 3 numbers in a row like that. 1A1. For 6 months of probation, concurrent with the 6 months probation on count 2. Substance abuse evaluation, any recommended treatment, anger management course, which can be completed online. 622 court costs, $100 cost of defense, waive costs of supervision, and no contact with the victim. Is that the agreement that you've made with the state?
Yes.
Is that what you want to do today?
Yes.
All right. Have you gone over this agreement with your lawyer?
Yes, I have.
Did you understand and sign it? All right, are you satisfied with your lawyer's advice and representation?
Yes, I am.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No.
Are you currently suffering from any mental health issues?
No.
Has anyone forced, pressured, or threatened you in any way to enter this plea?
No, sir.
Has anyone promised you anything in return for your plea?
No.
You understand by entering the plea there won't be a trial of any kind?
Yes.
You understand you're giving up your trial rights, which are on page 2 of the agreement you signed?
Yes.
Do you understand you're waiving all potential defenses?
Yes.
And do you understand that if you enter a plea and you're not a citizen of this country, you could be deported?
Yes.
All right. So what is your plea to the lesser included offense of misdemeanor battery, first-degree misdemeanor, and simple assault, second-degree misdemeanor?
No contest.
All right. I'm going to accept your no contest plea as freely, voluntarily, knowingly given. On count 1, which is the misdemeanor battery, 6 months of probation, adjudication of guilt, substance abuse evaluation, and any recommended treatment, complete anger management course, which can be done online, 622 court costs, $100 cost of defense, waive cost of supervision, no contact with the victim. Count 2 will be adjudication of guilt, 6 months of probation concurrent with the same conditions, correct?
Yes, Your Honor.
With the same conditions as count 1, waive cost of supervision, no contact with the victim. Any questions, Ms. Dean?
No.
All right. I'm going to have you talk to probation. Well, do you want her to do probation first? All right, we're going to do your fingerprints first.
Yes.
Then talk to probation, then
Yes.
you've got 30 days to appeal the judgment and sentence.
Okay.
All right, good luck.
All right, thank you.
Ms.
All right.
Judge Oberliesen, sir, I have no further cases. May I be excused?
Sure.
Thank you.
You're welcome.
Mr. Enzemacher. Sorry for the, right there. Yep. You're fine. Oh, you're fine. Yep, sorry for the delay in getting you here. Your Honor, this is Mr. Enzemacher before the court in 23 CF 1532. He's back from the Florida State Hospital, Your Honor. They did recommend that he be found competent to proceed. I have lingering concerns, Your Honor, so I will be requesting an additional competency evaluation and awaiting the results of that.
Any issues, Ms. Leone?
No, Your Honor.
So I'd ask for a continuance, Your Honor.
All right, October 29th at 9 o'clock. Make sure to get that order to my office so I can get it signed and you can get that evaluation.
I believe it'll be internal. and
Oh, you're doing it
it's been done.
internally?
Yes, Your Honor.
Okay.
Yes, it's been done now.
All right, let's make sure it gets done by that time.
Yes, Your Honor.
All right, thank you. Wait, I'm sorry, did you say it's been done already?
No, sir.
Okay. All right, got ahead of myself a little.
Smart. Your Honor, this is Mr. Jeffrey Moore.
Okay.
Your Honor, we still need to get the motion to suppress set. The state and I have talked about it. I think October 9th would probably be the best day to do it. I believe that's your next miscellaneous date outside of September 25th. That should be more than enough time to give Dr. Ward enough notice to clear out her calendar and get her here, Your Honor.
And that's on the 24 CF 2894.
Yes, Your Honor.
Have you filed the motion?
Yes, Your Honor, the motion's been filed. We had previously set it for hearing. I did file a notice of hearing on that, but that fell through.
All right, so it'll be October 9th at 2 o'clock for the motion to suppress. Make sure you file a notice of hearing on that, Mr. Maddox.
Yes, Your
And
Honor.
we'll put the cases also on 10/29 at 9 o'clock for pretrial conference.
All right, thank you. I'm seeing you, Mr. Moore.
Thank you, Your Honor.
Need a new signature for me. Nine two today.
I know my birthday's Thursday.
All right, Your Honor, may I approach?
Yes. not seeing the 1087 case.
Yes.
It's on the back, Your Honor.
No,
No,
on my docket.
Your Honor, that one is actually in the south end. It has not been transferred, but I already spoke with Mr. Snell, and he is okay with me resolving that today.
All right, Mr. Robinson, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
So help me God.
And can you state your full name and date of birth, please?
Baron Kerry Robinson, September 4th, 1969.
All right, and Mr. Robinson, you're here in 25 CF 577 with 2 counts of possession of controlled substance, which is our third-degree felonies, and punishable up to 5 years in state prison. You also have 6 counts of possession of drug paraphernalia. Those are each 1 year maximums as first-degree misdemeanors. You also have a drive-while license suspended or revoked second-degree misdemeanor punishable up to 60 days. Also, as announced from the south end, you've got a case 25 CF 1087 where you're charged in count 1, counterfeiting the license plate, third-degree felony, 5 years maximum, and then also attaching tag not assigned, drive-while license suspended, and no vehicle registration, each of which are second-degree misdemeanors punishable up to 60 days in jail. Do you understand all that?
Yes, sir.
That's what you're currently charged with?
Yes, sir.
Okay. Now, I've been handed a plea and sentencing agreement that would call for you to plead no contest. In the 577 case, it would be as to counts 1, 3, and 9, with the state dismissing the rest of the counts. And then in 25 CF 1087, it would be pleas to counts 2 and 4, and the state would be dismissing 1 and 3. Is that your understanding of it?
Yes, sir.
All right, and then the court would ultimately sentence you to 2 years probation and some costs. Does that sound right to you?
Sounds good. I asked for withhold on that, if you don't mind.
Well, if it's not an agreement, it's.
I've spoken to Mr. Robinson about that, Your Honor.
Okay. All right, so it's an adjudication of guilt on everything that he's pleading to?
It is, Your Honor.
Okay. Now, again, if that's the agreement, that's the agreement. I'm not going to.
Yes, sir.
Put myself in between you and the state and what y'all agree to. All right. Did you go over this plea and sentencing agreement with your lawyer?
Yes, I have.
Did you understand it?
Yes, sir.
Did you sign it?
Yes, sir.
Are you satisfied with your attorney's advice and representation?
Yes, I am. Took me a while to get there, but I am.
Let me ask you, your other cases from the south end, did you have a different lawyer down there?
I had.
He did, Your Honor. He had Mr. Koch,
Yes.
I believe. There was a.
Mr. Maddox, if I could ask him the questions.
Oh, I'm sorry.
Yeah.
No, it's fine.
Yes, I had Mr. Koch.
Any issues with Mr. Koch and how he
No,
handled
he
your
was
case?
fantastic. He was fantastic.
All right, y'all. Everything is recorded in this room, so we can't talk over each other. If you interrupt me, Mr. Robinson, then the record's not clear. So just wait till I finish the question, and then you can answer. All right. Did you have any issues with Mr. Koch, who was representing you in 25 CF 1087?
No, he was fantastic. He did a great job.
Okay, I just want to make sure that there's not an issue because you had 2 different lawyers on 2 different cases in front of 2 different judges. All right. Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues?
No, sir.
Did anyone force, pressure, or threaten you in any way to enter this plea?
No, sir.
Has anyone promised you anything in return for your plea?
No, sir.
Do you understand that by entering a plea, there won't be a trial of any kind?
Yes, sir.
Do you understand that you're giving up your trial rights, which are on page 2 of the agreement you signed?
Yes, sir.
Do you understand that you're waiving all possible defenses?
Yes, sir.
And do you understand if you're not a U.S. citizen, this could lead to your deportation?
Where are you going to send me? Yes, sir.
All right. We'll bring you back at the end. Mr. Robinson, this is not a joking matter.
I apologize.
I have to advise every single person, if they're not a citizen, they could be deported.
Right. I am a citizen, and I understand.
And I didn't ask that question because I'm also not supposed to ask that question.
Right.
So I just don't appreciate that you're taking this so lightly.
I'm not taking it lightly at all.
You're pleading to felony convictions.
Mm-hmm.
You're being placed on probation, and it's not the time to joke.
I apologize.
I'll call you back later. Thank you.
I did not mean to offend you.
It's not offensive. I just want to make sure you're taking this seriously.
I apologize on behalf of my client, Your Honor.
understandable, but I'm just not going to turn this into a comedy hour
And
about
it shouldn't be one.
about deportation and people's constitutional rights.
I certainly understand that. All right, Your Honor, this is Mr. Brian Stralfack before the court in 25 CF 440. Your Honor, last time we were here, we were considering what to do with this competency evaluation. I have another copy for the court if it needs it.
I don't have one.
Okay.
I've never been given one. All right.
Your Honor, the state and I are going to stipulate to the report. Someone highlighted, Your Honor?
I understand, Mr. Maddox, but I haven't had a chance to read it yet.
Oh, certainly, Your
So my notes were that there was consideration of getting a second evaluation, and that you might agree to just one, but no one's ever sent this to me to read.
Certainly, Your Honor. Yes, there were discussions. We've agreed to use this one.
All right, can you approach?
Yes, Your Honor.
Let's ask him.
Injured? Take a breath.
I've reviewed the report, Mr. Sofrak, that was done by Dr. Zeman back in May. based on y'all's stipulation, right? That you're
Yes, Your
stipulating to use of what, just a one report?
Yes, Your Honor.
All right. Then I'll make that, the finding that Mr. Sofrak is incompetent to proceed at this time.
And, Your Honor, based on that and the matters that we've discussed, after speaking with the victim, the state is going to ask that the case be dismissed without prejudice.
Case will be dismissed without prejudice.
Thank you, Your Honor. All right, we've reached a resolution in this matter. If I may approach.
Mr. Mayor, do you have the score sheet?
All right, so this is 1129 to do ECLC.
Correct, Your Honor. Waiving credit.
I think just the issue, that, again, with the language we come up with, complete ECLC versus comply with ECLC.
Comply. So, okay, comply.
I don't think there's ever an end point, right? It's.
This is a jail, ECLC.
Oh, I know.
So,
Well, basically, that he has to comply with ECLC during the entirety of the 11 months, 29 days of his jail sentence. But I don't think there's truly an end point. It's just, that's why we call it compliance as opposed to successful completion.
Since in my conversation, if I can be
As a friend of the court, go ahead, Mr. Williams.
In my conversations with Ms. Clow, in particular about Mr. Brawley, there is in the jail program, at least the dorm program, there is an endpoint. He's, for example, my guy's supposed to reach his endpoint December 16th.
All right, so if I put in complete, and he doesn't complete it in 11 months and 29 days, what do I do?
Well, that's a different problem, and if he's not on supervision, it's going to be hard to have accountability on that.
And that's kind of my point.
If the state is all right with it, Your Honor, I do believe in previous plea agreements, the comply language has been what's used. I would support that.
I just don't know.
And the other issues like we've had before, if they complete it earlier than there's to be released from jail, then under what mechanism are they released from the jail?
Well, in this particular situation, Your Honor, the state and I agree that the 1129 sentence is appropriate here, so that's not an issue for us, and I'm not disputing that. I guess this completion or compliance language would be the issue primarily here, Your Honor, and again, I'd be fine with compliance if that's what's been used in the past. I don't want to further
The reason I ask is because I had a case last week with Mr. Dixie Powell where they were asking for him to be released from jail early because he had already completed the program.
That's understandable, Your Honor.
Means you got to file a motion. We're going to talk about whether I'm going to let someone out of jail early. I think we just need to get to a consistent point with these things as to how we're doing it. Otherwise, it may be confusing, not just only with cases in my division, but cases in other divisions that may be using different wording than we are. So I'm not really being critical here other than just let's make sure we don't have any things that are going to jam up people who either finish early or don't finish at all, and how we treat that as potentially early termination versus a failure to complete. I just want to make sure everyone's on the same page. Maybe it's more of a interdivision thing that we all need to figure out with Judge Stone and Judge Clark and Ms. Claw. But I don't mind the language, I just don't want it to be a situation where someone feels later it's different than they were expecting.
Just one question, Your Honor. I don't remember when I signed. Do we have language here that it should be a condition of probation?
There's no probation.
No, there's no probation.
That's the problem. If we have to specify that jail is a condition of probation, because if in the meantime it violates in any way, there should be consequences.
Kind of like Mr. Peacock's case with
Yes.
Ms. Rivers, and she's not in her head along.
Yes.
And that's why, again, it's the lack of uniformity, which is my concern with it, that one person comes and does it this way, then the next one comes the other way.
Yes.
And again, I'm not trying to be critical, I'm just trying to be consistent.
So based on what the court said with Ms. Rivers' case earlier, that was it was placed on administrative probation, and then the jail 1129 with compliance with ECLC would be a condition of that probation.
Okay, but now Mr. Maddox is going to have to discuss that with him so he understands, because if you're on probation, even administrative, and you don't comply with the program, or you commit a new law violation while in the jail, then you're looking at potentially violating your probation and subjecting yourself to a lot more exposure of jail or prison. And again, I'm not trying to tell y'all how to do it. There are agreements that y'all make with each other. But
No,
I can't be in a situation where people it's inconsistent. Go ahead, Mr. Maddox.
Well, I'm sure the state and I will be able to amendably work this out, Your Honor. My client's the state and I have been working diligently to resolve this case. He's been in jail for, since January. He's waiving all of the credit up until then. I do think comply with the ECLC program, even in light of the state's concerns, would be appropriate here. But again, I can't, I'll talk to the state, I'll talk to Mr. Webb, we'll work this out if we could just pass him briefly.
We can pass it until y'all can talk some more and talk to Mr. Webb about it. I'm not trying to punt this to some other date, especially if it involves changing his credit date. I just want to make sure everyone's on the same page.
And I appreciate that, Your Honor.
I'll give this back to you, Mr. Maddox, but we'll call him out later today.
All right, thank you, Your Honor.
All right, we'll see you in a little bit, Mr. Webb.
This afternoon, you said, Your Honor, call him back?
Whenever we can get back to him, yeah.
Yeah, so.
At this point, depending on how many people we have, we might have to take a little bit of a lunch break, but.
Understood.
I'd like to get at least all of the out-of-custody people done. I think, Mr. Williams, are you the only one that has anyone out of custody at this point?
I do.
And then as far as Ms. Tintle, Mr. Maddox,
Yes.
I never saw her on Zoom. She may have been there for 2 hours before I knew to check, because I didn't realize she was going to be on Zoom.
Judge,
So if you could, she's still on the docket, if you could see if, I know you might not have a way to contact her based on what you told us earlier, but see what y'all can do in the meantime.
Yes, Your Honor.
All right, Mr. Williams.
Delmarcus Barkley, 24 CF 172. Judge, this is a negotiated plea.
Thank you. Mr. Barkley, can you raise your right hand? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth? All right, Mr. Barkley, you're here on 24 CF 172, charged with possession of a firearm or ammunition by a convicted felon, which is a second-degree felony and punishable by up to 15 years in state prison. Do you understand that? I've been handed a plea and sentencing agreement that would have you plead no contest to that charge. You'd be adjudicated guilty, 2 years of probation, waive costs of supervision, $515 court costs, $150 PD fee. Is that the agreement you've made with the state? And just to make sure it's clear, is this, Ms. Leone, is this yours?
Yes.
So is it not a firearm, or is it constructive possession? Constructive possession. I just want to make sure it's clear.
Yeah, yes.
All right, so what you're pleading to, Mr. Barkley, is possession of a firearm, constructive possession, which would remove any potential minimum mandatory. All right, is this what you want to do today? All right. Mr. Barkley, did you go over this plea and sentencing agreement with your lawyer?
Yes, sir.
you understand and sign it? And are you satisfied with your lawyer's representation and advice? Are you currently under the influence of any alcohol, drugs, or controlled substances? Are you currently suffering from any mental health issues? Has anyone forced, pressured, or threatened you in any way to enter this plea? Has anyone promised you anything in return for your plea? And do you understand by entering a plea there won't be a trial of any kind? Do you understand that? All right, and do you understand that you're giving up your trial rights, which are on the first and second pages of the agreement that you signed? And you understand that you're waiving all potential defenses that you may have to the charge? And if you're not a U.S. citizen, do you understand that you may be deported because of this? All right. And what is your plea to the constructive possession of a firearm by a convicted felon? I'm sorry.
No contest.
No contest. I'll accept your no contest plea as freely, voluntarily, knowingly given, adjudicate you guilty, place you on 2 years of probation, waive cost of supervision, $515 court costs, $150 PD fee. This is a guideline sentence. I've reviewed the guidelines that show 36.20 points, so there was no lowest permissible prison sentence. All right, Mr. Barkley, I'm going to need you to get fingerprinted up here, then talk to probation, then you have 30 days to appeal the judgment and sentence of the court. Thank you.
Judge, the next case I have is Anthony Brown. This likewise is a negotiated plea.
Maybe not. Yeah. It's a downward departure.
And Judge, this is a downward departure. Legitimate unforced plea.
All right, Mr. Brown, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Sir.
All right, can you state your full name and date of birth, please?
Anthony Scott Brown, 12/23/1985.
All right, and Mr. Brown, you're here in 24 CF 1140, where you're charged with possession of a firearm by a convicted felon, which is a second-degree felony and punishable by up to 15 years in state prison. Do you understand that?
Yes, sir.
I've been handed a plea and sentencing agreement between you and the state where you've agreed to plead no contest in return for being adjudicated guilty, 24 months of probation, 24 hours of community service, waive costs of supervision, $515 in court costs, and $150 PD fee. Is that your understanding of the agreement that you're making? Yes. And is that what you want to do today?
Yes, sir.
Is that the state's agreement?
It is, Your Honor.
All right, and again, this is a constructive possession due to the fact that there's no minimum mandatory being imposed?
That's correct, Judge.
Okay. I mean, it's written there, I just want to make sure I've heard
Yes,
that. All right, Mr. Brown, did you go over this plea and sentencing agreement with your lawyer?
I did, yes, sir.
Did you understand and sign it? Are you satisfied with your lawyer's advice?
Absolutely.
And are you currently suffering from any mental health issues?
No, Your Honor.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, Your Honor.
Has anyone forced, pressured, or threatened you in any way to enter this plea?
No, Your Honor.
Has anyone promised you anything in return for your plea?
No, Your Honor.
You understand if you enter a plea, there won't be a trial of any kind?
Yes, Your Honor.
And do you understand that you're giving up your trial rights, which are on page 1, and going on to page 2 of that agreement that you signed?
Yes, Your Honor.
Okay. And do you understand you're waiving all potential defenses?
Yes.
And do you understand that if you're not a U.S. citizen, this could lead to your deportation?
Yes.
All right. And what is your plea to the possession of a firearm by a convicted felon?
No contest.
I'll accept your no contest plea as freely, voluntarily, knowingly given, adjudicate you guilty, 24 months probation, 24 hours of community service, waive costs of supervision, $515 court costs, $150 PD fee, as previously announced. by the parties. This is a downward departure based on an uncoerced plea bargain between you and the state. So you understand that means the only reason you're not going to prison based on this
Absolutely,
plea is
yes,
because
sir.
the state agreed to it.
Yes,
All right. All right, I need you to get fingerprinted, Mr. Brown, then talk to probation. You have 30 days to appeal. Thank you.
case one more time. It was set for plea or trial. It's a trafficking case, Judge, dealing with controlled substances that were found in a pair of pants in the floorboard of a vehicle.
Okay. So what else needs to be done?
Judge, I think mostly spend some more time with him and maybe try to see if I can talk the state down again.
Okay. State have any objections?
No, Your Honor, no objection.
All right. So I'm not one that normally puts cases plea or trial twice.
Yes, sir.
So if we come back and it's set for trial, it's going to be a trial.
Yes, sir.
So I'm going to call this last continuance. It's getting a little on the older side.
It'll be 10/27 at 1, Judge.
10/27 at 1 o'clock. Yes, sir. We'll see you back on that date, Mr. Krivick. Stay in touch with Mr. Williams so he can work on this case for you.
Yes, sir.
All right.
Thank you.
Thank you.
Thank you, Judge.
Thank you, Mr. Williams.
Judge, the last one that I'm showing is, I have Mr. Calbo also.
Oh, yes. Did I not give that to you?
Judge, can we approach on Mr. Calvo's case?
Oh, okay. That's why I was like, this feels late. Sorry about that. Approach, is that what you said?
Yes.
Okay, sorry.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
You been injured in an accident and need righteous representation? Call us, because we fight fire. Damn thing ain't working.
Whoa! Not cool, bro. I'm Attorney Coy Browning. Personal injury is no joke. Just ask him.
Injured? Take a breath. Call Coy.
We're open Saturday 10 to 4, Sunday 10 to 3, and that's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
Mr. Calvo, sounds like they're still exchanging some information regarding a resolution to the case. I'm going to call this your last continuance. It's going to be October 27th at 1 o'clock will be your next and last pretrial conference.
I understand, and I know it's been delayed a lot for various reasons.
I understand, but it's a year and a half at this point.
Yeah, I know. I'm sorry. Thank you.
Judge, the only other out of custody that I have is Dalton Norris, and the court had tasked me with trying to figure out where he is. I don't have any information other than, in part because of
HIPAA, and nobody can tell me anything. Other than I did review the notice filed by his bondsman, and the bondsman indicated he went first to West Florida Hospital. They have a facility there, the Pavilion, and then wound up at Lakeview. And so that's the last information I have on him, would put him at Lakeview Center in Pensacola. They do have inpatient facilities there.
But otherwise, he hasn't been to court, right?
Judge, he had, I believe, a pretrial conference. We were appointed at arraignments. He had pretrial conference on 6/23, and it was passed from there to 8/25. I don't have any indication that he was not in court on 6/23, but the clerk's office should have that.
6/23, the minute sheet says that he has, he's got a capias.
Okay.
Not sure why he's on the docket.
Yeah, my notes just said defense continuance 8/25.
Should have been, I don't know how he got on to 8/25, because there was a capias with no bond done on 6/23. And I don't see where it was removed.
Yes, sir. Ordinarily, I would have noted that and then turned the file in to be closed, but I still had it, and I had it noted 6/23 defense continuance, but my notes may be incorrect. Somebody has to always be right, and typically it's the clerk.
The capias is still active. All right, so I'm going to take it off the docket for its capias status. It was effective as of June 23rd with no bond. Obviously, if you find out where he is and that you can show an explanation of that he's been in some sort of inpatient
Yes, sir.
facility, I'll consider removing it upon filing of a motion.
Yes, sir. Judge, that's all the out of court, I believe, that I have. I don't know if we were going to do Ms. Barrettman's 2 remaining cases, or
However y'all want to do them. I just would, it's 12:19. I'd like to take some sort of a abbreviated lunch break.
Yes, sir.
Before we get through the rest of them.
I will say I've killed my alarms.
Okay.
I would like to see if you can discuss those offers with clients, so I'm
Sure.
okay to waive the offer line, just kind of cancel those on them.
That'll be fine.
I have one more out of custody, Judge.
We've got the 12:30 pretrial detention as well.
It's up to you. If you want to take a lunch break, it's up to you.
Any suggestions?
We could address the pretrial detention, Your Honor, because of an issue that came up.
Okay. Can we get Mr. Prince?
If you can get Booker and Gary, I'll go talk to them.
All right, so this is 25 CF 1620, State of Florida versus Connor Prince. We're here for a pretrial detention hearing. I believe y'all filed one. I'm not sure when it came in. I just saw that it came in this morning.
Yes, the pretrial detention motion was filed on Friday afternoon. I'm going to request it for the record, Your Honor, a continuance to Thursday at 12:30 for the reason I would have to approach.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Backbone Bakery Cafe is 2 blocks from the courthouse on Crestview historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by.
I'm Amanda Gaskin with Briarpatch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
You've been injured in an accident and need righteous representation? Call us, because we fight fire. Damn thing ain't working.
Whoa! Not cool, bro. I'm attorney Coy Browning. Personal injury is no joke. Just ask him.
Injured? Take a breath. Call Coy.
We're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
All right, what we're going to try to do, Mr. Prince, is put you on later this afternoon because we have some availability issues, but we'll readdress you at about 3:30.
Yes, sir.
All right. All right, we'll readdress it at about 3:30.
Yes, sir.
Hopefully we're done with everything else before then. All right. Do we have anyone else that's in custody or?
I have one out of custody, Judge, with the plea.
That's what I meant, out of custody. Sorry,
It's going to be Michael Bell, Judge. Case numbers for the record are 24 CF 1340, 24 CF 1355, and I have an agreement and a score sheet if I may approach.
Yes, sir. All right, Mr. Bell, can you raise your right hand? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, can you state your full name and date of birth, please?
Michael Eugene Bell, Jr., 1178.
And Mr. Bell, you're here in 24 CF 1340, where you're currently charged with possession of a controlled substance, possession of drug paraphernalia, and resisting without violence. And then 24 CF 1355, obtaining goods with invalid title and possession of a motor vehicle with an altered serial number. Do you understand all those charges?
Yes, sir. Yes.
All right. I have been handed a plea and sentencing agreement that counts for, or that calls for you to plead to count 3, the resisting charge in the 1340 case, pay court costs and a PD fee and adjudication of guilt. In 24 CF 1355, you'd plead as charged to the obtaining goods with invalid title and possession of a motor vehicle with an altered serial number. Be an adjudication of guilt there. You understand those are felony convictions?
Yes, sir.
All right, 18 months probation, each count concurrent, waive cost of supervision, pay court costs and a $100 PD fee, restitution of $730 at a rate of $70 per month minimum, subject to random UAs. And court costs in the misdemeanor would be $270, and court costs in the 1355 case would be $515. Is that what you want to do today?
Yes, sir.
Is that the state's agreement?
I apologize, Your Honor, speaking with the victim.
Okay.
Is this Mr. Bell?
Yes, and it looks like you've signed the.
Yes, this is the state's agreement, Your Honor.
Okay. All right, Mr. Bell, have you gone over this plea and sentencing agreement with your lawyer?
I have, Your Honor.
And did you understand and sign it?
Yes, sir.
And are you satisfied with your attorney's advice and representation?
Yes, sir. I am.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues or concerns?
No, Your Honor.
Has anyone forced, pressured, or threatened you in any way to enter this plea? Has anyone promised you anything in return for the plea?
No, sir.
Do you understand by entering a plea there won't be a trial of any kind?
Yes, Your Honor.
Do you understand you're giving up your trial rights, which are on page 2 of the agreement you signed?
Yes, sir.
Do you understand you're waiving any potential defenses?
Yes, sir.
Do you understand that if you enter a plea and you're not a U.S. citizen, it could lead to your deportation?
Yes, sir.
All right, and Mr. Bell, in the 24 CF 1340 case, what's your plea as to count 3, resisting an officer without violence, first-degree misdemeanor?
No contest, Your Honor.
All right. I'll accept your no contest plea. In that case, is freely, voluntarily, knowingly given. State have an announcement as to counts 1 and 2.
Yes, Your Honor, the state is going to null pros those charges.
All right, 24 CF 1355, what is your plea to the obtaining goods with an invalid title and possession of a motor vehicle with an altered serial number?
No contest, Your Honor.
I'll accept that no contest plea as well as freely, voluntarily, knowingly given. And the resisting charge, it's $270 court costs, $100 PD fee, adjudication of guilt. I'm not sure I can make him pay the costs to his probation in another case.
Then we would just, Judge would then ask just for 90 days to you to pay.
What I'll do, Mr. Bells, I'll give you 90 days to pay those costs or set up a payment plan with the clerk, but I don't think I can take costs from one case and put it on probation from another, since he's not going to be on probation at all on that case. In the 24 CF 1355, adjudication of guilt, 18 months probation, concurrent with each count. Waive cost of supervision, court cost of $515, $100 PD fee, restitution of $730 to Lucas Derringer at a minimum of $70 per month. Is that to be paid through probation?
Through probation, please, Judge.
All right, so that restitution will be paid through probation at a minimum of $70 per month. You're also subject to random urinalysis. This is a guideline sentence. I've previously reviewed the guidelines that come to a total of 8 points. Anything that I've missed?
Not from the defense, Your Honor.
Nor from the state.
All right, Mr. Bell, I will need your fingerprints, then have you talk to probation before you leave, and you have 30 days to appeal the judgment and sentence.
Thank you, Your Honor.
Thank you. Yes, time served for the misdemeanor. Sorry, doesn't usually do that. I'm trying to. Who else do we want to call, or are we ready for?
Judge, the only 2 people that I have left that we might call would be to accommodate Ms. Barrettman, and that's Booker and Gary. Both of those will go quick.
I'm trying to get everybody I can get out of here within reason.
Yes, sir.
But it'd be nice to have a little bit of lunch and stop talking for 30 minutes.
Yes. Yes, sir.
I think I'm still in recovery from last week.
Judge, this is Ricky Booker, 24 CF 354. We're negotiating back and forth. I just gave him another new offer. It was set plea or continuance. He just needs to think that new offer over a little bit. We can set it either for a miscellaneous date or we can leave him on the 1029 docket.
I'd prefer to set him on the October 9th with where we're going to put Mr. Gayo if we can.
That's fine.
All right, Mr. Booker, what I'm going to do is put you down October 9th at 9 o'clock for purposes of a possible plea. I'm not obviously requiring that you plea, but just in case you're going to, we'll do it on that date. Your next pretrial conference, if it doesn't result in a plea that day, will be October 29th at 9.
Okay. All right.
But I'd like to resolve this one by the next cycle because it's pretty old as well.
Thank you, Judge.
Thank you.
Judge, on Mr. Gary's case, we have an offer for 24 months credit for time served. He's not going, I need to spend some more time with him because of his mental history. And so what we're asking to do is to set this for October 9th as well. At that point, he'll be 2 days shy of having the full 24 months done. And I anticipate we're going to be entering a plea on that date.
Any other evaluation issues?
I don't believe so, Judge. I've not seen anything to suggest that he's decompensated, and the latest evaluation was for not guilty by reason of insanity.
That's why I was just making sure there's nothing else to
I don't
do.
think the state's asking for another evaluation at this time.
That's correct. We're
Case is
hoping to come to a resolution.
3 days short of 2 years.
Yes, sir.
And I understand why it's been delayed, but, all right. October 9th at 9 o'clock for a possible plea, otherwise October 29th at 9 o'clock for pretrial conference. Thank you, Mr. Ko.
All right, Mr. Carey, you'll come back on October 9th, okay?
Oh, I'm sorry, Mr. Gary.
Mr. Gary. No.
No, I got it wrong. You got it right.
All right, Judge, I think that's all we were going to try to get done before lunch.
Okay. You done, Ms. Beckerman?
I am, if I could be excused. Judge.
Yes.
If I may, Your Honor, do you want to recall Mr. Robinson back now or after?
We can do it after.
Okay, that's fine.
All right, so let's take about a 30-minute lunch break. We'll call it 1:20. Y'all want more, or